Supplementary list for orders, item number 1.
See, we do not approve of this practice of filing interlocutory applications in pending matters, that too for extension of time. And for this purpose, we have to constitute a bench.
This was a disposed of case, my lordship.
Yes, disposed of case, then why?
Liberty was granted to us to file an application for fixing a time limit.
Why? If the time limit was not fixed then why should it be done now?
We had filed a contempt. Lordship has directed since contempt won't be maintained because no time limit has been fixed.
Then there is reasonable time. There is a reasonable time for complying with the order.
The time period was extended.
That we will not do. Once the matter is disposed of, we should not entertain. And this practice is very rampant. It's not done.
Since the period was coming to a year period was coming to an. So
what period?
We are not in a position to get more work because we were blacklisted, my lord. So this honorable court, after hearing, had quashed that order, granted us the liberty to approach them. A show cause was given. We had appeared, given our representation. Hearing was completed, my lord.
Then
thereafter, no orders were being passed. So
then your blacklisting order has been set aside.
Yes.
Then there is nothing against you.
But we were.
You can have a separate grievance. Different cause, separate cause of action. Why in a disposed of matter you will file an application? You can file an application if there is any clerical mistake, if there is any typographical error, that can be done. But you want modification of the order in disposed of matter in such way.
I'm sorry, my lord.
We don't approve.
So
They have not followed the mandate of OPWD code. So in that light, we have disposed of the writ petition. So action as deemed proper, that will be taken
As you wish.
in accordance with that.
See, just think of when you file an application in a disposed of matter that there must be something very serious. Because for that, a bench has to be constituted, you know.
I'm sorry, my lord.
If you file a review application, it's all right. We will entertain. But review you cannot file in this case. Therefore, this application, IE number
10750 of 2024.
Application has been filed. Incorporating time limit for compliance of this court's order dated 11/12/2023 passed in WPC number 20031 of 2023. For compliance. For compliance. Stop. Next. It is apparent from the order dated 11/12/2023 that an order of blacklisting dated 5/6/2023 passed against the petitioner was set aside with an observation with a liberty set aside, and the matter was remitted back to the authority concerned for reconsideration. Stop. Next, we see no reason for modification of the said order by prescribing a time limit for the concerned authorities to reconsider and take decision in terms of the said order dated 11/12/2023. There. Is it in liberty? Let me see where is the liberty.
Where is that order? You have stated so. Should have stated so.
Fixing the time within with that liberty doesn't mean it. Does not do that. No problem. In any view of the matter, by not fixing any time limit, the petitioner's case cannot be said to be prejudiced. Stop. When counsel for the petitioner has argued that because of the pendency of the matter before the concerned authority, the petitioner is not being awarded any work.
We are not being allowed to participate in tenders through the online portal.
Not being allowed to participate on online tender.
Through online tender. If it's open for us only, then we can bid.
Online tender. So stop. As the blacklisting order has already been set aside by this court, we see no reason why the petitioner should not be allowed to participate. So stop. That is, however, a separate cause of action, which the based on which separate cause of action for which the petitioner can take appropriate steps in accordance with law, including by approaching this court by filing a writ application.
My apologies, 1 second, madam.
Item number 2.
I have the appearance for OP number 5.
What is this about?
Dismiss for default for restoration.
Restoration. What was disposed of?
WA.
All right.
Dismiss for default because on that before that I am suffering from gastric and
All
other
right.
diseases.
Restored.
My lord, the
Office notice. It is like this.
entered appearance for OP number 5. But the ground stated in the
It was dismissed for default.
my lord,
That's all.
on the ground of illness of
All right.
conducting counsel.
Forget.
A 97 days delay has not been explained.
97 days delay has been, whether delay has been condoned or not. Delay of 97 days in filing the present application. Is it? Yeah, condoned, restored. Yes. Decide cases on merits, why delay?
Have you not given your memo earlier? I think you have given your memo earlier.
It has not been listed.
Mr. Please, this is to all the members of the bar that I personally go through each and every slip and I direct the registry to place orders. So therefore, just to
Lord, I may be pardoned, my lord. Lord, I may be pardoned, my lord.
Yes.
In WPC number 14789 of 2024, the matter was listed on 29th August. My lords were kind enough to permit me to make a mention today. It's a very urgent matter, my lord.
give your slip. We'll see.
My lord, another
listed.
No, my
It
lord,
is
it is not in the list, my lord. Listed
All
on
right.
Monday. Another.
Ah.
In another read appeal number 511 of 2024,
Yes.
the matter was listed on the 17th May 2024, on which date the lordships were pleased to almost on the verge of disposing the writ appeal. But the respondent took a technically take an adjournment for which the matter could not, and even though the matter was listed on 24/6/2024,
Send your slip. Miles.
deeply obliged.
Item number 1.
My lord, wait, please, your lordships. My lords, may kindly have a look at the last order. Your lordship wanted to know, my lord, what has the Pollution Control Board done? Now, the Pollution Control Board has sent its report, and that report was uploaded for us to file our comments. That was uploaded on 27th of August, and we have filed our comments on the 1st of September. So now it is under consideration by the CIA. My lord, only because your lordships are monitoring it has happened. I would only request, my lords.
No, we would like to know
Yes, my lord.
the procedure, the system.
Yes.
How
this whole thing moves.
yes, right from the very beginning.
Correct. Would your lordship then call it sometime next week, my lord? I will prepare a chart and give it to your lordship. Maybe 1 week after.
Please, you also
Yes, Lord.
tell us so that see, on the ground of pendency of something,
Absolutely.
see, the operation of law takes place.
Correct.
So therefore, you will have to,
It has to be streamlined, my lords.
and who grants?
My lord, ultimately the MOEF will grant. So your lordship may call it 1 week after. We will prepare 2 charts, complete charts, step by step, what is to be done. Grateful.
My lord, extremely apologetic, my lord.
Why?
I realized that there was no mentioning. I thought there was a page-wise mention.
Hmm.
I'm extremely sorry. I'm extremely sorry. I thought you.
No, she wants to mention something. I said, let my matter get.
All right. What happened? Tell us.
This item 29, it is fixed to 2 p.m. today, my lord. And there is some personal difficulty. I'm for the advocate for the respondent, my lord. I have taken consent from the appellant counsel,
Make a mention at 2 p.m.
my lord.
And senior counsel appearing on behalf of the petitioner has submitted that in the light of this court's order dated 13/8,
Yes, well.
dated 13/8/2024, the State Pollution Control Board has made its report, which is made its report that has been uploaded on the website.
Yes, my lord, on the portal.
That has been uploaded on the portal. So stop. A response of the petitioner has been sought.
And already given on 1st of September.
Portal on 30th.
So that it was uploaded on 27th
On 27th.
of August.
27th.
And my reply was furnished on 1st of September.
Requiring the petitioner to submit its response. The response, he states, has already been submitted on 1/9/2024.
My lord.
Stop. List this matter on how much time?
2 weeks, minutes.
2 weeks. 2 weeks. Retaining its position. So stop. On the next date, the court will require senior counsel for the petitioner and learned AGA representing the estate to address this court on the point of procedure for grant of environmental clearance.
Yes, ma'am.
Since it has been noticed that absence of environmental clearance because of delay in grant of environmental clearance has serious consequences on grant and renewal of mining leases.
Grateful.
Under the law.
Right.
Item number 2.
In item number 2, I tried an affidavit stating therein that so the principal of the BJP college was requested to give the details of the financial amount which shall be released in favor of the petitioners. Now he has given a letter that 4,65,751 has to be released in his favor. Now file has been processed. This is the letter I've given a copy to my friend. Still takes some time, so also and the 10 days time. In the meantime, it shall be paid. The entire
2 weeks.
Yeah, lots of fixed date.
2 weeks, yes. It will be taken up, it will retain its position
17 weeks.
as
It will come on.
AGA.
17.
Like,
See, Mr. Counsel, we are also equally worried when our orders are not complied with.
because the petitioner is not getting his full pension.
All right, you are worried about your money, we are worried about our orders.
Retired since 2012.
We'll see. It has been stated by learned AGA representing the contemners that steps have been taken to ensure that the petitioner is paid his amount which he is entitled to under the orders passed by this court.
No.
Passed by the tribunal.
No,
Was this all good? Read up, please.
No. A writ appeal was dismissed.
Yes, sir.
Order was by the
ordered by the tribunal.
yes.
The tribunal dismissed my petition.
Oh, you're
This
right.
honorable court allowed.
Right. Then the petitioner is paid his entitlements in terms of the order passed in WA number so and so. So he seeks adjournment till 17. To top. Huh?
It's WPC minutes. Read petition.
Oh, sorry, WPC. This matter on 17/9/2024, retaining its position.
Submission item number 3.
This matter, the relief claimed in the writ petition is squarely covered under Orissa State Abolition Act 1951. And as per roster discipline, the matter is to be decided by the division bench. But inadvertently, it has been decided by the single judge. That is the problem. It is one aspect. And if
Did you raise this plea? Did you raise that plea before the learned
My
judge?
lord, my lord,
You had raised.
my lord.
All right. Let us see the High Court rules.
My lord,
Let us see the High Court rules. It must be there in the High Court rules, Master.
my lord, as per arrangement, I know, I'm sure this matter, OEA matter comes before the division bench.
Sure, on the basis of your general knowledge.
No, my lord, it is there as per distribution of business.
Distribution is in accordance with the High Court rules.
Constitution of bench and matters
Distribution-
assigned to the different benches.
Very difficult.
Yes, that is why you are being asked that where is the assignment that it should come before the division bench.
Not only assignment.
Assignment,
In the assignment, Mr. Counsel, is in accordance with the rules.
my lord,
So as per the High Court rules, it must be there.
my lord,
Have you
So-
checked?
it's a constitution of different benches.
No, that this matter is an endowment matter,
Not estate abolition.
estate abolition matter. Yes.
Estate abolition
Yes,
matter.
yes.
जरा हाई कोर्ट रूल है ना मिला असाइनमेंट
A bit of submissions on the basis of general knowledge.
High Court rule.
without examining this aspect, why have you taken this point? This is under OSS. Yes, who is appearing for the other side?
No,
Yes, is there any merit in this?
Lords, but technically which Lords point by Lord Senior raising, if you also kindly come to page 15.
Yes,
An application under section 226 and 227
Yes.
and provisions of the Orissa Sovereign Settlement Act. Orissa Sovereign Settlement Act assignment is of the Honorable Single Judge, Lords.
yes.
So it was heard by Honorable Single Judge, Lords.
But my point is the relief claimed in the writ petition, not whatever the nomenclature of the writ petition says.
So nomenclature was given by whom?
Relief claimed by the writ petitioner.
Nomenclature was given by whom?
Nomenclature,
High Court.
It has been mentioned.
Nomenclature was given by the High Court.
No, my lord, it is there in the writ petition by the petitioner himself.
So, see,
The
Mr.
relief-
Counsel, since you are taking a plea of jurisdiction of this nature, if we find that there is no merit, we may impose cost on you for this.
No, on the whole petition, the relief claimed is under Orissa Estate Abolition Act. Because Survey and Settlement Act cannot decide the title of the petitioner.
In your cause title, you have stated that it is under the provisions of the
That is there,
Orissa
that is
Survey
there.
and
Cause
Settlement Act.
title, it has been mentioned under Article 226 and 227, provisions of the Orissa Survey and Settlement Act. But relief claimed is substantially comes under Orissa Estate Abolition Act. Right
So
is
you
not decided.
wanted some decision on the point, whether it should be heard by a division bench or a single bench. Because you gave the subject you mentioned in your writ application
My lord.
as OSS. And then you want that the High Court should have decided that it should go.
No, my lord, that is not my point. But
Page 17, paragraph number 2, my lords.
that is there, my lord, may come to the prayer of the writ petition. That has been mentioned in the first page in the nomenclature, but the prayer is substantially under Orissa Estate Abolition Act.
Prayer, there is nothing. Only annexure 567.
I am just placing the prayer.
Yes.
The petitioner in the facts and circumstances view of the position of law humbly prays that your lordships may be graciously pleased to admit this writ petition, call for the court's lower court records of the connected cases issue notice to the opposite party and stay for the proceedings taken contemplated pursuant to Annexure 8. Annexure 8. So Annexure 8 was under challenge. Annexure
Annexure
8.
5, 6, 5, 7, 8, 9. You challenge Annexure 5, 7,
Annexure
8, 9.
8. Annexure 8 is the order passed by the member board of revenue. That was challenged. It was passed on the basis of Annexure 9. Annexure 8 and 9 both were challenged, and Annexure 8 was the order of the member board of revenue which was challenged in the writ petition.
Under the Orissa Survey and Settlement Act.
What?
Annexure 8.
Yes, Annexure 8 is the order of the member board of revenue.
Under the Orissa Survey and Settlement Act. Please
No,
take
that-
a look.
The member board of revenue has relied upon Annexure 9. That was an order passed by the OEA collector. OEA collector. So 8 and 9 both were challenged. Annexure 8 was the order passed by the member board of revenue, which relied upon Annexure 9. That is the order of the OEA collector.
Which
That
order?
was also
Just a minute,
challenged.
just a minute. Which order was under challenge before the learned single judge?
My lord, both the orders, Annexure 8 and 9.
So how do you say that this is OEA matter?
Lord, this is OEA matter.
Annexure 9 was filed under section 32 of OSS Act.
No.
Please
Annexure.
come to page 45, Annexure 9. We will have to examine the statutory provisions also, but please come to Annexure 9.
Well, Annexure 9
Yes.
is the order passed by the OEA collector.
Annexure 9 is the order passed by.
OEA collector.
Annexure
Orissa
9 is the order passed by
Establishment
Member Board of Revenue.
Order passed by the Member Board of Revenue. OSS case number 22 of 2006. As per the annexure you have marked.
No, Annexure 9, Lordship may come to page 1, 2.
1, 2.
The list
Your
of
Annexure 9 is at page 1, 2.
Right. In the index itself.
Mark the annexures incorrectly, I think that is the problem.
It seems you are misleading us, Mr. Counsel. Please come to Annexure 9.
Yes, Annexure 9 is the
Page 45.
Annexure 9. That is the order of the OEA collector. Annexure 9 at page 47. 45 to.
Problem is you have marked page 45 as annexure 9, which is of the Member Board of Revenue.
Well, that may be a mistake, but in my copy.
Your copy, we can't go by your copy, we have to go by this copy. From this it is apparent it is a mistake, but that mistake has been committed by you. Because this must be the last page of that order, that is why it's stamp is there. This stamp is there.
No.
Annexure 9 which you have marked in the writ petition is some different case. And the order given by you from page 47 is something else.
Page 47, the orders.
As per page 45, is dated 8/3/2006.
8/3/2006.
Yes.
Yes, that is the order.
Page 47, it is 18/1/95. So you check up and then come.
I'll take time to
What is this?
reconcile this position because in my copy, Annexure 9 is at page 45.
So we cannot
That-
come,
that
Mr.
is-
Counsel. We cannot come there to decide your case.
It is right. That page tallies with our page here. So look at what that page is.
OSS case number 22 of 2006.
Exactly.
6.
Yes, member Board of Revenue.
The,
Have you taken this plea in your memo of appeal?
my lord,
You have taken this plea
my lord.
that it should not have been decided by the learned single judge. Whether you have taken this plea as a ground in your writ appeal or not.
My lord, absolutely.
that?
Absolutely, I have taken.
You have taken that ground carefully.
My lord,
Have you taken that ground carefully?
my lord.
Please come again day after tomorrow. Prepare yourself and then address the court. And please, you can take the risk of taking that ground.
Page 47, order dated 18/1/95.
No. Now you realize we made some mistakes. So please come back day after tomorrow and point out the mistakes and then argue. Because with this we can't. You are referring to some other annexure, but it is not that annexure. And if I remember correctly, had you filed a writ appeal earlier and withdrawn it to approach this court after disposal
Right.
of the review,
Your lord,
then why have you not stated that in your certificate?
your lordship is.
Why have you not stated that in your certificate? Because I remember you had filed a writ appeal. It was probably disposed of, granting you leave to file a review before the learned single judge.
That your lordship's order is annexed with this writ appeal. The order which your lordships have passed, that order is annexed with this writ appeal.
All right.
Yes. All right.
When do you want?
No, that-
Mr. Counsel, you are simply wasting the court's time.
I'm sorry.
No, Mr. Kaur, do you have a problem with hearing?
No. I have
Then we are asking you so many things, you are not responding.
no. Your lordship's
Yes,
order.
lordship order is there, you have not mentioned in your certificate, but we want you to get prepared and come and not waste time of the court. That's why we are asking you, when do you want? We are asking you, when do you want?
That order is Annexure C, which have.
Yes, we have understood. List this matter on Monday. As requested on.
1 week time so that
1
I
week,
can
Monday is 1 week.
All right, we are giving you enough time. 4 weeks.
reconcile that position.
Yes.
Yes, we have so many things to do.
Item number 5.
Lord, there is a noting. I have a small prayer for amendment of the writ petition that has not been disposed of. There is an application was filed for minor amendment of the writ petition that is there on board, your lordships. That may kindly be allowed so that I can file a
What is that
corrected.
amendment?
In fact, originally it was filed making the association of this All Orissa optometrists as a party. It was listed before the Honorable Single Judge. There it was pointed out that the association should not be there as a petitioner. So thereafter I have deleted the name and a small paragraph was also changed. Paragraph 2 of the writ petition was changed. So that application is pending. That may be.
If you
kindly
change
allowed.
the petitioner with that same writ
Oh, no.
petitioner,
We'll have to file a fresh application.
if you change the petitioner, can the same writ petition?
2 petitioners are already there.
Already.
Just let.
It is there because all total there are 3 petitioners. Now the association is being deleted only.
Okay. Delete
Ah,
it,
that
then it is
can
all
be
right.
done.
There now individually will continue the case.
Yes. I number 6245.
Yes. The second is
I number 9097.
yes 909724.
So this is for deleting only, no?
Deleting the name of the petition number 1 and substituting paragraph 2.
this application has been filed for deletion of petitioner number 1 from the area of the petitioners and permit the petitioners to continue the writ petition through petitioners number 2 and 3 in their individual capacity. Top. The application, this application is allowed. Let petition number 1 be deleted from the area of parties. Consolidated.
Consolidated. You have to file the consolidated writ petition.
I have to file the entire writ petition because 2 consequential paragraphs are also
Yes.
changed. That paragraph 3 of that petition, it is there.
And along with the index?
Yes. I will file a corrected entire writ petition. I will file.
So the consequential amendments are also required to be made in the pleadings in the writ application. Stop. The petitioner is permitted to file a consolidated writ petition. Consolidated pleadings. What do you call it?
Consolidated writ petition.
Writ petition.
Consolidated. All right. Writ petition. How much time?
During this week, I may file. Let me call on Monday or Tuesday next week.
1 week. Yes, this matter 2 weeks.
Item number 6.
Not in this case, I have
May I please-
already received the para reply yesterday. Kindly grant some time to so that I will file counter affidavit.
Milord, am I
received
audible?
para-
Milord, they have taken time on 2 occasions. Kindly give a time-bound direction so that the pleadings can be completed and the matter can be heard.
Yes.
My lord, grant some time. My lord, I have already received the para reply, my lord. 2 weeks kind time you granted, I will file
2
counter
weeks.
affidavit.
Yes, and Milord, your lordship may give me a week to file a rejoinder if required.
All right. 2 weeks time is 2 weeks further time is allowed to the opposite parties to file counter affidavit. Stop. List this case on 4 weeks. Stop time in the meanwhile may be utilized by the petitioners to file a rejoinder to the counter affidavit if so
Yes,
required.
Great.
Obliged.
Yes.
Item number 7.
Milord, I just had one other request. There is another matter at 28, and your lordships had directed today also both to come up so I can physically assist my lord. That may also come up on whichever date my lord fixes this matter so that I can be present physically to assist my lord.
Let that reach Mr. Jan.
No, yes, my lord. I'm only requesting that both may come on the same day, whichever
Let
day
us-
my lord gives it.
Let that matter be taken up.
Yes, we'll do it at 20. Request is for the same. Grateful. Milord.
Item number 7.
May I please, lordships? My lord, the petitioner is a supplier of manpower to, he has been supplying manpower to OP number 2 for the last 3 years. And by Annexure 6, his services have been terminated, the tender has been terminated, and he has been blacklisted.
So you have challenged what?
I have challenged the blacklisting. There is an IA for stay, but now it is infructuous as the different agency, some other agency has already been engaged in the meantime. I'm challenging the blacklisting.
So where is that order?
My lord,
Where is the blacklisting order?
Annexure 6, my lord.
Annexure?
Annexure 6,
Page?
page 15.
No, they're not blacklisting.
My lord,
Nothing to be entertained.
Hmm?
we received a letter
Perpetual.
at Annexure 4,
Set
my
to
lord.
cancel.
The allegation was that
What
the
is this? All right, well,
Municipal.
this notice will go, no?
my lord,
Notice will have to be issued. This Office of Municipal Council, Japni. Notice will go.
This is municipal council.
Issue notice. 1 week, 6 weeks.
obliged.
Item number 8.
Madam, you've implemented the executive officer,
Ask.
not the municipality. Please look at your cause title, madam.
I'm sorry.
Whom have you implemented as opposite party number 2?
My lord, the Jatni Municipal Council.
You have implemented the executive officer. The municipal council should be represented by the executive officer.
So in the meanwhile,
It
you
is a
take
mistake.
steps.
No,
We are
I-
not saying anything.
You are
Do
issuing
whatever you
notice, but for in your interest, you do it.
You discuss with your senior and then do whatever
Right.
is required.
You are Miss Mishra.
It's item 8 may I pray for tomorrow, my lords. There's two regulations, my lords, I have not got.
Or
Great.
Item 9.
Lordship, this matter is with regard to your lordship might not have heard to hillocks outside the Indeed and outside Bhubaneswar, Khandagiri and Udagiri to hillocks. They were converted to caves of Jainism during the time of Kharavela. My lord, I am praying I prepare a short date chart so that it will be easy for me and for your lordship.
is this a PIL?
It's a pay. No, it's not a PIL. The association who is those who are taking care of the organization. It's not a PIL.
Date chart is already there. Date chart is already there at page.
Yes.
Yes.
I have made a date chart.
You want to make a better date chart?
No, not that. To equip, just to make my lord
there.
sequence of submissions.
Or synopsis?
No, synopsis and date chart.
Synopsis. Synopsis is just formality.
Date chart.
Do it,
also.
do it. Do it. When do you want?
My lord?
When will you do? What time?
Tomorrow.
Council appearing on behalf of the Krishna states that he wishes to file an improved date chart. Date of chart or chart? Date chart.
Date chart.
Date chart. So stop. As requested, is this matter on 2 weeks? So records of that. Huh?
Yes, sir.
Also along with the records of OJC number that is pending.
That OJC 2750 of 1996.
Yes.
Is it pending?
No.
As per your date chart, you have said that instructions were sought to be taken in that.
Thereafter, my lord, I think it has been dismissed for default.
Yes, it's been disposed of.
Along with the records of OJC number.
2750 of 1996.
Item number 10.
We are also calling it tomorrow.
2 weeks.
Item 10.
1 week at least, your lordship. 1 week.
Let it come.
Please, Malak. In this case, I am challenging the advertisement, the criteria
Advertisement of?
opposite parties will. Page 89, Annexure 6.
Yes.
That the criteria, lordship, kind of lines. Where the petitioner is a divar to participate in tender process. Petitioner is an individual contractor
having a long experience, my lord, is continuing such efforts and works since after getting the license, my lord. Here in criteria, your lordship, the authority only invited tender, the company, partnership firm, unlimited partnerships and society association act, and Indian trust fund. Whereas my lord, petitioner is debarred to participate, my lord. And so far, I am continuously having a long experience, my lord.
Maybe
My lord.
that is the condition that cannot be said to be unreasonable.
Only because to favorism, my lord, towards
Maybe.
others.
You also form a company.
My lord,
You can also form a company.
now I am an individual. Your lordship decision, your lord, so far as on which cases your lordship case in Rajkishore Sawan state of Odisha. Your lordship held the malified intention and favorism towards the injured
All
authority.
right. That can be distinguished.
That in that case, your lordship may interfere. I have already worked, my lord, under this authority, my lord, in several times. It said works, my lord. I have done such work. Even if the authority I have done under the said authority, I have number of time, my lords. But now in this year, my lord, you have been restricted to participate in tender process, my lord. Whereas the other, my lord, annexer 5, the another CDMO in same another district, they also invited the individual tender. Whereas there is a one department, there should not be a two law. The whole department, health department, my lord. Totally the action of the authority, my lord, malified intention to favor some group of person, which is unreasonable, my lord, and malified intention.
Stop you from having a partnership firm or a company or stop you.
Well, now I am individual. Subsequently, I have developed my rights. Now I am individual. Your lordship, let me allow to participate. Subsequently,
Now you are individual.
now you are sole proprietors. I am.
You are individual. Now you are one.
No.
Earlier there was a partnership firm.
Earlier, no. Now I am continuing since long as the individual partners. Individual sole proprietors.
How long will it continue?
Subsequently, in latter stage, I will develop. But now, your lordship allowed to participate.
How long will it continue? You are an individual. What is the average life? What is your age?
38, my lord.
But Mr. Rao, the advertisement is of the February.
February month.
So how can we allow you to participate?
But now no work order has been given. Not every work has been completed, my lord. That whole tender process has not been completed and no work order has been given, my lord. I have received instruction, my lord.
Why did you tell him? Why did you tell him now?
I filed 31st July, my lord. This case I filed 31st July, my lord.
Last date was P2 2024.
24, my lord. Whenever I have did the pre-bid discussion, he has not been communicated to us what are the steps I have taken. Thereafter, I filed, my lord. Within the process of tender process, I have filed, my lord.
So
What is the date of your filing?
31st
August.
July, my lord.
July.
July, my
31st
lord.
July means after 5 months. After 5 months.
Even if, my lord, after 6 months, 1 to 80 days, with approval of the authority has continued. But till now, the tender works process has not been completed, my lord.
Okay.
The annexure 6 series.
6,
Page 88.
89.
Challenge the advertisement.
Right.
Advertisement dated.
Criteria, my lord. Clause 2 and 3.
RFP for the wrong. Right. 31st of July 2024. From RFP that period of availability of RFP document was between 2024 to 2024 and last date and address for submission of proposal for the 26th to 2024. So, and on this ground alone, in our considered view, this application deserves to be discussed. So, when council copy had submitted that, so far the work order has not been issued. So, in our opinion, that is inferior for the reason that if the petitioner intended to having any eligibility criteria, he could have approached the court within a reasonable time, keeping in mind the timeline prescribed in the RFP. Secondly, the challenge to the eligibility criteria is secondly, following eligibility criteria as prescribed in the RFP has been put to challenge by page 91. But often hearing on behalf of the petitioner has noted that such condition has been imposed to out competition with malafide intention and to favor those who qualify the so the state commission in our opinion is not at all sustainable. So the condition as the eligibility criteria as described in the RFP cannot be said to be such as is required with sport exercises, exercising spirit reservation. There are 226 of the Constitution, particularly in the matter of award of contract.
That one. All the collected records.
So what are the others? Same,
All are same.
38 same.
same thing.
But here,
But paragraph 10 of the first writ application, you have stated advertisement dated 16/7/2024. That's a typographical error, I suppose.
next is same.
No. Paragraph 10 of the first writ application, page 11. What is that?
The earlier advertisement.
That's a typographical error.
2 to 24 advertisement.
All right.
Item number 11.
Well, all are not same.
Sorry.
All are not same. Then second one you address.
Third, 19,642 malad. Where at advertisement 19,624.
19638 is same.
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 Here, malad. Advertisement at 19,624. Annex of 6 malad.
Sorry.
Here, malad. I will now continue. Last date submission.
No, in this case, any other ground or the same grounds?
Last date was 11/7, my lord. 11/7 was the last date.
No, but grounds are the same.
Same, my lord.
19/7/24, my lord. Last bid of submission.
That is the opening of the tender. Submission is 11/7.
Same ground, your lordship decision
Same
is
ground.
there. Lordship case, Rajkishore South State of Odisha, your lordship categorically observe which case, my lord, on what circumstances your lordship interfere. And that our own judgment also is there, my lord, is there, your lordship allowed. This.
Show us any judgment of any court of the world where the court has held that because the only company or those who have been mentioned can participate, therefore that eligibility criteria is valid.
Our own judgment, my lord. Yours.
Any judgment of any court of the world.
Lord.
Did you hear what was asked?
Judgment.
No, the judgment you are relying on, is it on the point that where the sole proprietorship firm has been excluded? Is it on that point?
No. The judgment is there, my lord, where initially stage the petitioner has been excluded. Subsequently, because has experience and previously has worked there, has been tender bid has been included, my lord.
Mr. Counsel, every action which excludes you from participation is nullified.
My lord.
And that is unfortunate. Every action of the state which excludes you from
Well, states every action to
qualify, therefore the action is nullified because you are the only person qualified.
I am not qualified. I am not participate, my lord, in tender process. But since long I am work.
Yes, please give that decision.
My lord.
For other cases.
Yes. Initially, my lord, the petition has been excluded, but subsequently, the writ petition was allowed and direct to participate in tender. And the criteria which has been deducted, my lord, the stipulated the criteria, but they struck down and subsequently I participate to tender process, my lord. That lordship. And here, my lord, I am since law. There is no manner I am ineligible, my lord. I am eligible, my lord, since long and specify this one. I am continuing since last long. My lord. There is no reason, my lord, to reject. Only to.
What has been held in this?
Then subsequently allowed, my lord. Subsequently has been excluded, sir. Initial stage has been excluded. See, here, lordship, here the annexer 5, my lord. Here the another CDMO, the said health department, he also given the advertisement where individual has been given. Annexer 5, lords, you can see.
By the
Yes.
authority which issued this advertisement or the other one?
This advertisement, my lord, another district and same authority, my lord. Lords, you can see page 51. And same CDMO, my lord, CDMO of another district in his advertisement, allow the individual sole proprietors, my lord. That's a principal health department. There should not be a two law. That is a whole depend upon the instruction of the state, my lord. Lordship can see annexer 5, my lord.
After appearing on behalf of the band upon
My lord.
You said Rajkishore Sahu, you have given some other decision.
Rajkishore Sahu, your lordship judgment.
Proprietorship, sole proprietorship.
There is no decision to of any form, no decision of any form has been cited to the effect that the eligibility criteria in the nature of the bidder must be registered as a company, partnership firm, limited liability partnership, society, or a trust. Reputed society registration act or a trust in the unit of land. And this will be under the
Item number 11.
Wait, please. This, the matrimonial issue has earlier engaged your lordship's attention last year also. This is regarding, Lord, claiming that the serving personnel in the defense services should be included in the policy of reservation made by the state for medical education. Earlier, last year, it was also challenged, Lord.
But your lordship held that since the admission is already over, question of interfering will be academic. However, next academic session, if you like, you have to raise this question. Well, till 2014, my lord, the policy planning board and the government of Odisha followed the reservation so far as ex-serviceman is concerned, my lord. Based, my lord.
What is the last date for admission?
Last date for admission is application for admission.
Last date fixed by the Supreme Court for admission to MBBS courses.
The counseling is not yet over.
Just asking, because the Supreme Court has fixed a deadline that cannot be crossed by any court, anyone.
Should we get the last date? Supreme Court deadline on last date.
Last date was probably September. Sometime this month. Now they are having the
counseling
for the management quota.
That is not the question.
Exact
the question is that if this writ petition remains pending before the cutoff date, the court loses jurisdiction.
That's right.
Cannot entertain. So in such matters which relate to MBBS admission, because it is time bound, you have better approach the Supreme Court. We cannot extend the date.
I am not asking your lordship to extend the date.
We are saying something else. We are saying that this writ petition has been taken up for the first time today. We may be asking them to file counter affidavit.
Your lordships. But the short point is, last year, lordship sees the same question couldn't be decided due to paucity of the time. This year also, I approached the.
So, are you sure that we shall be deciding this question before the last date of admission?
If your lordship likes, your lordship can decide it, because it is a very small point. It has to be decided whether that reservation, so far as ex-serviceman is concerned, which was decided by the government of Odisha in 2014, will still remain in force in view of Annexure 6, Otherwise, this problem will be coming every year. This year also, immediately after your lordship disposed of the other writ application, I have gone to everybody, to the Chief Secretary, to the Secretary, Scientific Development, Technical Education, to the Sign Board, but nobody helped me.
Yes, let us see what is the next.
Lord, till 2014, my lord, your lordship is essentially page 15. May I draw your lordship's kind attention, madam? Has your lordship got it? The ex-servicemen 3% reservation, my lord. The reservation policy of the state government will be followed for selection and shall be scheduled tribe 12%, scheduled caste 8%, physically challenged 5% of each category, ex-serviceman 3% category, my lord. This, my lord, is in force in pursuance of the policies of reservation, my lord, since 2014, my lord. My lord, in 2018, page 28, Annexure 6, my lord, your lordship may kindly have a glance, my lord. Has your lordship got it?
Yeah.
May I draw your lordship's kind attention, my lord, to page 28, my lord. My lord, to the Chief Secretaries of all states, my lord, it is addressed to
Page 18.
28.
Page 28.
28.
Yes.
Has your lordship got it?
Yes.
May I draw your lordship's attention? This letter was addressed from the Department of Ex-Servicemen Welfare to all the Chief Secretaries of all the states, my lord. Priority 5. Has your lordship got it? Priority 5. Wards of ex-servicemen and service personnel who are in receipt of gallantry award. Then 1, 2, 3, 4.
8 mention in dispatches. That is, I am having that guarantee out. Then a priority 8, words of serving personnel. But earlier, this priority category was challenged, but I am not there because your Lordship I already heard in a writ appeal that there cannot be a reservation within reservation in 2014, my Lord, in a writ appeal. Whether that is will survive in view of the latest Supreme Court decision or not, that is let me not get into those things, my Lord. My Lord, now this was addressed to all the secretaries and the state of Orissa, but it has to be adopt this that instead of ex-servicemen, it would be servicemen, whether ex or present or not serving. But the policy planning board is helpless unless the government gives a directive. And I went to the government told me to approve the policy planning board. I went to the policy planning board. I wanted a sign board to give me a registration, at least that I am entitled. They refused, telling that unless there is a policy, we cannot do that. Last year also the same thing happened, but the admission was over. Now this year is also the same thing, Lord. Unless there is a direction from your Lordships, I don't think anybody will be able to help me.
You just want enforcement of
Annex 6.
And there should be some consideration of this Annex 6 by these state laws.
Yes, ma'am.
That's all.
Yes.
Yes, ma'am.
Take instructions, Your Lordship.
Thank you.
Now that counseling is going on, but there is still time. If they decide that servicemen will also be included by ex-servicemen, then I will be considered, my Lord.
Because Your Lordship, in Annexure 1, Your Lordship, they have given here, there it says that candidates whose parents are continuing in defense service are not eligible for reservation under this category.
Annex 1, I placed page 15. That is
Page 16, Your Lordship.
That is unchallengeable. That is what I say, that this.
If they take a decision, that will apply from the next category, next category.
But even if I go to the Supreme Court also, your Lordship knows that it will take time to be listed.
Even if they take a decision today,
it will at least give me a chance next year.
Next year, we can do it.
Yes, Your Lordship.
Yes,
Your Lordship.
There is right.
I will get back to your Lordship on the date. If your Lordship calls it after lunch, exactly last date I'll get back. If your Lordship directs, I'll keep one seat vacant.
For the reason that in no case the court will allow the petitioner's counseling for the present academic year in
Madam,
view of
that's fine.
clear
And because,
Annex 1.
and because there may be other candidates also on the
Also,
same
yes,
footing.
that notice thing will be there. That your Lordship is
They would
100%.
be deprived. But once it is clarified, everybody will have a
So
chance.
that everybody will have a chance. There may be others.
Yes. Very fairly.
Lordship may declare the policy.
At least there should be clarity.
There must be some decision on this point, my Lord.
Lordship may decide the rate.
Recurring thing.
So decide that.
Recurring things.
Yes,
Lord, can there be an intermediate of reserving one seat?
Not in this case, because of that clause.
Your Lordship notes down my prayer and rejects it.
Where is that, madam?
Page 16, Your Lordship. Annexure 1, page 16, Your Lordship.
Clause 5.
Clause 5, Your Lordship, last line. Candidates whose parents are continuing in defense services are not eligible for reservation under this category.
This is triggered by that other one.
That is against that.
Yes, Your Lordship, 2018.
This was pursuant to
pursuance of the 2014 policy.
Yes. Annexure 5.
Thereafter, after 2018,
This was
nobody
pursuant
has
to Annexure 5.
bothered to look into the Government of India circulars and
Annexure 5, if your lordship comes to Annexure 5, just to assist your lordship, and I have no stake in this. Annexure 5, my lord, the department has clearly stated the flow of events right from the division bench and then the confirmation by the Honorable Supreme Court. And that is how the 14 ex-servicemen category was enforced.
no, set at 2% to
This is
set a priority will not be taken into consideration. Only reservation will be taken into consideration.
But after 2018,
Nothing has happened.
no, this will now govern the field powers. Latest policy will probably govern.
This is given heading courses 24-25. Annexure 1.
Central government directive. No?
Central government directive.
Central government directive. That will govern.
Guidelines and instructions for the discussion on the operation of state legislation. There is no need release all India ranks or provide for reservation in the matter of admission to MBBS when previous courses in 2024 and 25.
Five. Note 5.
Five of which reads the which apparently don't like you. Does not permit reservation for
Walls of serving. The last line.
for
Candidates whose parents are continuing in defense service.
candidates whose parents are continuing in defense service. Next. This writ application has been filed seeking direction to the opposite parties to register the petitioner's name against ex-serviceman quota in the light of policy decision of the central government.
Only 6.
Central government. All communicated to all the English government and union territories to data dated 21/5/2018 bracketed annexure 6, which permits a reservation also for wards of working army personnel in given circumstances.
Serving person.
That is in priority 5 and priority 8.
5, 8, and 8.
9.
5, 8, and 8. 5, 8, and 8.
No, yes, but category was down below here. It has been raised. Priority has been raised.
No, but there in 2014 policy.
Yes.
The service, the wards of the service were entitled for reservation.
No.
No,
Ex-serviceman.
no, only, sorry.
Only ex-serviceman.
Only ex-servicemen. That is why the difficulty.
14 was only ex-serviceman.
That 14 still governs the field irrespective of annexure 6.
After 18,
Yes.
this. Carefully.
Children of ex-servicemen.
Service.
Date of birth.
The state of Minnesota taking clear stand as regard implementation of Annexure 6 and implementation of the communication dated 21/5/2018, which has been brought on report by way of Annexure 6 of the retirement. Said that the review must be filed within 2 weeks from today. Matter of secretary. 2 weeks. Within some time.
All right. But in all fairness, if your lordship would have been persuaded to at least decide the matter in the earlier writ application, your lordship would have.
So it's a matter of policy.
I don't.
This candidate can be eligible even in the next year. All right, so the only because the academic year is the question.
I shouldn't say. The submission from the bar should have persuaded you in the earlier writ application.
Item number 12.
So, the petitioner here is a successful bidder. In the tender process, he was classified as the L1. There are only 2 bidders in the field. The petitioner was L1, the other one competitor was L2. Now, initially I had approached this honorable court with my grievance that my tender is not being finalized. That's a matter appearing in my lord's list at serial number 53. But here is the case, my lord. After I filed the writ petition, they communicated me a decision of theirs, which is at page 107 of my writ petition. They have rejected my technical bid. My technical bid was treated to be qualified. My financial bid was opened. I was classified as L1. Thereafter, based on the petition of my competitor, the L2, my technical bid is rejected on the ground, on the precise ground that I have not declared debarment of a work in my tender paper. I have not declared debarment of a work in my tender paper. My competitor raised a grievance that Sardar Sarovar Nigam Limited in Ahmedabad, Gujarat, that I was blacklisted. That is what has not been declared by me, which is a requirement.
So your writ petition at item number 53 has become infectious.
But that I am not appearing there. So the concerned counsel who is appearing, he will address my lords on that. But here I am challenging my rejection of my technical bid. Lord, my technical bid was opened.
Where is that?
Lord, that is at page 107.
WPC is before this court, not was before this court.
Beg pardon.
As per your certificate, you have said WPC so and so was before this court.
Is before this.
Is before.
That's a typography error, matter. I beg excuse for that. But kindly see page 107, bottom paragraph. As for finding of the technical committee held on, may I be permitted to place it now?
Yes.
As for findings of the technical committee held on 9/11/2023 based on petition received on 27/9/23 against bidder Maruti Construction Special Category 1, roads contractor for another tender work improvement such as so-and-so work in the district of Moirvanj. Maruti so-and-so construction was technically disqualified as per DTCN clause 11 for not declaring a debarment of a work by SSNL Ahmedabad. As the financial bid of this tender work has already been opened prior to receipt of this petition, and bidder Maruti Construction declared as L1 bidder and negotiation made with him, hence necessary clarification in this regard was sought from the government.
In the meantime, so-and-so classified contractor who has been selected L2 bidder for this tender work has filed a writ petition bearing number so-and-so. Before this honorable court has directed to consider and dispose of the representation of the L2 bidder. Messrs. Big Bid Infrastructure Co. Special Class Contractor in accordance with law. Accordingly, L2 bidder Messrs. So-and-so has submitted his representation citing to call him for negotiation for his quote rate. As such, government in work department has initiated intimated to this office by letter number so-and-so to send tender proposal of the said tender work for taking further action at their end. Based on technical bids, participated bidders, evaluation sheets of all bidders are placed before the technical evaluation committee and finding of the committee are as follows. So, after detailed discussion of the committee, recommended to open financial bid of single qualified bidder. Kindly similar, single qualified bidder of the contractor on 2-8. First of all, it contravenes 2016 Supreme Court. Single bidder under the OPWD code would not have been considered. That's a question your lordship will consider. Secondly, declaration with regard to debarment of work, if your lordship will see, I have filed an Ahmedabad High Court judgment. In para 19, the Honorable Ahmedabad High Court has exempted me for the simple reason that Ahmedabad work was in favor of RK Infra. I was not the contractor. Eventually, from RK Infra's account, some money has been transferred in my name to my account. That is why I was roped in that, along with RK Infra in that proceeding and others, entire allegation I was roped in. But the Honorable Ahmedabad High Court has clarified that since I was not the contractor there is no question of blacklisting me there. So therefore, I am not required to declare that I have been blacklisted. Question of blacklisting doesn't arise against me. That is what is clarified by the Honorable Ahmedabad High Court. 1. 2. If your lordship would kindly see.
So where is that Ahmedabad High Court?
That is at page 123, the relevant para is para 19. I was blacklisted there. I challenged that order. And this is what the observation is, my lord. Para 19. Page 123. Let's got it?
Yes.
We fail to understand why the Nigam in the first instance had to pass the impugned order. When no contract has been awarded to the writ applicant, then why Nigam had to say in the impugned order that writ applicant was being debarred from running the work at the site of the Nigam? Why should the writ petitioner be debarred when he was nowhere connected with Nigam? Prima facie, it appears that bogus bills were, along with bogus works, came to be prepared in the name of the writ applicant, and on the basis of which bills got sanctioned and huge amount of more than 2 crore ultimately came to be credited in the bank account of the writ applicant. How this happened is a matter of investigation. The writ applicant says that he is innocent, has no idea about such amount came to be credited to his account, and the day he came to know about this, he refunded the amount to Nigam. However, such explanation or defense of the writ applicant in this at this stage is not sufficient to exonerate him. The matter will be have to investigated thoroughly. We fail to understand why till this date the Nigam has not thought fit to file an FIR with top investigating agency like CID crime, state of Gujarat. Why only preliminary inquiry has been undertaken so far? It's been almost 3 years, but still there is no clarity as regards the alleged fraud. But that's an observation with regard to financial misappropriation, or if anything comes out, then necessary criminal action will be taken. But with regard to blacklisting the observation.
Who was the petitioner in that case?
I was the petitioner.
So it says, however, such explanation or defense of the writ applicant at this stage is not sufficient to exonerate him.
Money being credited to my account.
The matter will have to be investigated thoroughly.
Yes. The money was credited to my account. The circumstances in which it was credited.
Who is petitioner here? Maruti Construction.
Same Maruti.
Maruti Construction.
Yes, ma'am.
And let us see who was the petitioner before Gujarat High Court.
That is at page 109, proprietor Dhiraj Lal so-and-so. There is no para 3 of this judgment, your lordship will see. Page 110.
Dhiraj Lal Nagji Bhai Gorasia.
He is the proprietor of the Maruti. Lord, para 3 it is clarified. Page 110.
This is a firm, not a company.
Lord, proprietor, yes. Not a company, not a jurisdiction.
Construction company.
Lordship got that para 3, my lord.
Proprietor.
Yes, state.
Yes, I will obtain instruction in the meantime.
Seek instruction. And what is the stage of award?
That award has not yet been made in favor of L2 because he is the single bidder. That will offend 2016 Supreme Court 3366 man. And also the OPWD code. It can't be awarded in favor of, once my bid is rejected, a technical bid.
So they may not award.
That protection will be given to me.
No, they may not award. Because
they may not, Lord, I don't know what will happen because they have said here.
Why should
12 the date was fixed to 12 days for that order.
Kindly see,
Lord, my friend.
I don't want to join issues there.
No, I'm not joining issues. I'm saying only the date.
Kindly see the last two lines. After detailed discussion, committee recommended to open financial bid of single qualified bidder. That is what the stage is. It's up to my lords to consider.
No, not. How much time will it take for you to?
2 weeks time only.
2 weeks time. List this matter on 2 weeks. But issue notice will have to go L1.
Big part.
Notice will.
Notice
has the other.
Paragraph 3, you say that the petitioner company.
That's a mistake.
Mistake.
Company is the name, but it's a proprietorship firm. But I'll have to take out notice against OP number 5.
1 week, 4 weeks.
If I can pray for status quo agenda, subject to my lord.
Status quo, since, see, according to you,
right,
the single bidder cannot be awarded. So why should we presume that they will violate?
They should not violate. In fact, they should not violate. If they violate again, it's a fresh cause of action for me to come.
You can make a mention, you can file an application.
That's right, grateful.
Item number 13.
As per your lordship direction, present position of this is matter relating to admission in MBBS NEET examination twice declared result. Therefore, they have withhold, and they say that investigation is going on. Meanwhile, they have issued a so-called notice. Latest instruction of my client is that they have issued, and I have also replied. That is the additional affidavit filed today before a lordship. Annexure 7 is my so-called reply. And annexure page 23, annexure 6. The suspected, second line, during the course of investigation.
No. This letter was received by you.
Received on because I reopened on 30th, my lord. Because I could not reopen the mail. I lost from this place to that place. Why my result is withheld. So I have replied, my lord. With that, I have already replied and on page 24.
When did you file the writ petition?
I filed the writ petition, my lord, on 23/8.
So why did you not disclose this?
That is it. Well, a 19 years old boy, my lord.
No.
Sometimes.
No.
That is why
actually, on 30th,
that is why we were puzzled that till date, how come nothing has been communicated?
We opened the mail on 30th, according immediately. On 23, my lord, on 23/8/2024, the writ was filed. I filed the reply, I got it, I reopened my mail on 30th and immediately I replied after filing the writ application. That is the instruction of my associate counsel, my lord. I have categorically stated, or you can look at that paragraph 6, page 25. That though the show-cause notice was issued unto me on 14/8/2024, but due to non-verification of my mailbox,
they will consider your so-called reply.
Let them consider within the period of 7 days or 10 days. Let me know my fate. I've categorically stated at paragraph 6 that I
not happy with the conduct of your client.
No. Let's say look at paragraph 6 of my page 25.
What?
That though the so-cause notice was issued unto me on 14/8/2024,
yes,
but due to non-verification of my mailbox, I could not able to file the so-cause in time as stipulated in notice. Today at about 2 p.m., when I sought my mailbox, I came to know about this so-cause notice for which it is being delayed to reply the same, which is not intentional or deliberate.
All right.
Before that, my lord, I have filed the writ application. That is 23/8.
But he did not inform you thereafter that he has done this.
They have to take a decision on my so-cause.
No. The petitioner has not informed you about these developments which took place after you filed the writ petition.
Bow down. That is a categorical paragraph at page 6.
See the conduct of the petitioner. Because of him, we are under the impression, and you also were arguing that this thing, nothing is being reflected on the
That's what Lordship directed. I filed the affidavit today and disclosed it because we should be fair before your Lordship.
We are not here for such.
Let them take a decision within a period of 7 days or 10 days.
We will not say anything. We will not say anything. The present writ application has been filed. Taking direction to the concerned opposite parties, to allow the industry. Which item is this?
This is item 13.
Check 13.
20807.
Again? To quash the scorecard dated 14/8/2024, brought on record by way of annexure 4, as according to annexure 4. Stop. The petitioner had appeared in NEET examination conducted by
2004, 2024.
2024, conducted by National Testing Agency. Stop. Today, an additional affidavit has been filed, from which it appears that on the very same day, that is 14/8/2024, the National Testing Agency, under the signature of Director Examination, had put the petitioner on show cause for adopting unfair means in NEET UG 2024 examination. Stop. This case was taken up on
Yesterday. Yesterday.
Taken up on 2/9/2024. Stop. The court was not informed about the so cause notice having been issued to the petitioner as regards unfair means having been adopted by him. The petitioner is said to have replied to the said so called notice on 31/8/2024. Stop. In such view of the matter, with a liberty to the petitioner, in such view of the matter, this application is disposed of with an observation that who is appearing? NTA?
Yes, ma'am.
NTA you are appearing?
Yes, ma'am.
Okay, NTA you can appear. So it appears for NTA.
Central government also.
tell me. With an observation that NTA shall be at liberty to take appropriate decision on the petitioner's reply to this opposed notice.
I agree for stipulated time, my lord.
Intimate.
So otherwise I didn't, my entire year will go, my lord. All my
Your
efforts.
entire year should go.
Item 14.
Should not join medical profession.
Oh, Lakshmi.
May I please reverse. Led on 3rd July 2024, Miller, the petitioner awarded a PMG YOR. Sorry.
14.
Yes.
Your Lordship. On 3rd July 2024, Your Lordships, the petitioner awarded a PMGCA work with notice to proceed the work and date of completion is December 2024, my lord. And my lord, on 15th, a disqualified bidder, technical disqualified bidder came before Lordships. And 15th July 2024, Your Lordships, after the post agreement, he challenged the technical bid. Your Lordships confirm his disqualifications. I have annexed that order, but made some observation to he made an application for investigation of other. My lord, your Lordship have granted authority. My lord. This package was not subject matter of the writ petition. My lord. Because of this, this order, they issue notice me, stop the work and kept abeyance the my lord.
What is that order?
Your Lordships, the impung order, Your Lordship order. Your Lordship's order is at page 414, Your Lordships. Annexure 9, 414, Your Lordships. Paragraph 2, Your Lordship, mention the package number. The petitioner in the present writ application has put out the challenge the order dated 26 June 2024, where the petitioner bid has been rejected after he was declared qualified bidder in the technical evaluation result 15th March 2024 for the work name package number, my lord, over 24123 and over 2451, my lord, where he was qualified and again disqualified. Your Lordship's observation is at paragraph 8 and 9, Your Lordships. After having heard the learned counsel on behalf of the petitioner and learned government advocate for the state, we are view that the impugned decision to disqualify the petitioner does not require interfere in view of the admitted fact that existing commitment were suppressed by the petitioner. We would have gone into the question of violation of principle of natural justice, but in view of the admitted fact, as noted above, we are not inclined to entertain the challenge to the impugned order on the said ground. Paragraph 11, Your Lordships. Learned counsel for the petitioner, however, emphatically submitted that 3 qualified bidders suffer from similar disqualification and a specific complaint was raised by the petitioner in this regard. We therefore view that once the evaluation committee option to consider the complaint received from the outsider, it would not have been reject complaint of the same nature made by the petitioner on the ground that the same was time bad. But thereafter, Your Lordships are pleased to dispose of with some observation, Your Lordship. Lordship, kindly annexure 1 impugned order. It's a different, Your Lordship.
No, different, but like in that case, we did not interfere because he fairly admitted that those deficiencies are there. What are you saying in your case?
My case, agreement was
not agreement. We are saying, do those deficiencies exist?
No, my lord, my humble submission, my lord, Your Lordship, 3rd July tender committee qualified me. My price open.
Tender committee may have qualified. But we are asking about the deficiencies against which he has
Your Lordship,
complained.
annexure 1, Your Lordship, impugned order. They have not, Your Lordship, they annexure 1, they say, Your Lordship, kindly have annexure 1, my lord, annexure 1 and 2, my lord. It's not a subject, not a matter of the writ, my lord. Your Lordship, annexure 1.
Finalization of which case?
Finalization of that package number, my lord. 3 packages tender was invited.
You are challenging which order?
My lord, annexure 1, annexure 1 and 2, Your Lordships.
Annexure 1 and 2.
Yeah, Your Lordship, annexure 1 addressed to me, Your Lordship. Your Lordship, with reference to subjected severity, it is intimated you that as per the subject reference letter,
you are challenging annexure 1 or annexure 2?
1 and 2, my lord. 2 is the my lord, order of tender authority, and it was
council. Please come to annexure 1. What is there?
They directed not to start the work till finalization of further directive of Honorable High Court, my
So
lord.
that matter is over.
Over, my lord. Extremely sorry. Sorry.
Annexure 1 is over.
No, my lord, I may be permitted, my lord. Your lordship, the date of annexure 1 is, my lord, kindly mark 31st July 2024, my lord. Your lordship order in that is 15 July, my lord. In spite of knowledge of the disposal of the writ petition, they say that will further direction of Honorable Court, my lord. That's your
What is the
lordship.
question of further direction?
Your lordship, with reference to subjected, it is cited above. It is to intimate that as per the above subjected and reference letter, you are requested not to start the work till finalization of the case or further directives from Honorable Court of Odisha, Kataki, lordship.
Yes. So either the case is decided or further direction is issued while deciding the case.
My humble submission.
Mr. Counsel, he has rightly pointed out, the authority has rightly mentioned in the letter that till finalization or any direction issued. So till final, he could not have said that till after finalization you can start. So that would have depended on the nature of the order to be passed. So annexure 1 has become
My humble submission, your lordship. Your lordship's order related to your lordship's order date is, my lord.
No, we have not related it to any work order. We have said the allegations that you have suppressed regarding existing work commitments.
My humble submission, your lordship.
Yes, that has not.
All right. Since you are insisting, let us be clear on annexure 1. How annexure 1 offends you now?
Exactly, my lord. Your lordships are kindly come to my lord. My agreement, page 106, my lord.
Yeah, agreement is there. We are not.
My 9 calendar months, your lordship. I have noticed.
Mr. Counsel, the case was disposed of on that day.
My lord, on 5th, your lordship. My lord, 15 July 2024, your lordship.
Yes. Come to annexure 2.
Your lordships. Annexure 2, your lordship. Page 19, your lordships.
Yes.
My lord, this is, my lord, sir, in compliance of Honorable High Court Odisha, order arising out of WPC number 1615 of 2024 filed by Ritham Agrawal for the above works, you are hereby directed not to start the above work, and the agreement drawn in favor of the different bidder must be kept abeyance till finalization of case or further direction of Honorable Court of Odisha, my lord. There is no case at all pending, my lord.
Then
they stop the work because of this, your lordship's order in the name of your lordship annexure 1, the authority, my lord.
Authority stop the work or you have stopped the work?
Your lordship, that not to start the work, your lordship.
Not to start.
Your lordship, kindly annexure 1, my lord. Probably I am not able to convince your lordship submitting.
No, it is all right. You have said you are directed not to start the works and agreement is kept in.
Finalization of case.
No, case is, there is no more case, your lordship. That is disposed of, your lordship, by 15th July.
That case is disposed of. But are they not inquiring into the allegations against you?
No, so cause, my lord, nothing as this stage, your lordship, kindly see the, my lord. The tender condition provides that can. My lord, the tender condition, that is a post agreement, my lord, they can't cancel also, my lord.
Oh, you mean to say even if some irregularity or suppression is detected after the agreement, they cannot do anything?
No, my lord, after the agreement, they cannot.
Yes, who is for the estate?
Not solved. Copy solved.
What kind of?
No, my lord, already served the e-copy solved, my lord. I have
When served,
my lord, I'm just giving mobile. All copies
serve at the last moment, they cannot get.
No, my lord, I'm just confirming, my lord, when is served.
You must have filed yesterday.
My lord, email where this is e-filing. After filing, unless you file the copy to the state,
it seems that you are your client is trying to make out a case that you are not able to start the work because of this order. Because this order does not prohibit you from executing your work. Both either annexure 1 or annexure 2.
After annexure 1, your lordship, I made ventilated grievance that this order is confined to this, and I have already proceeded.
You are ventilating grievance in the office instead of executing your work.
Stop, my lord. If you
No, because the thing is that not start the work till finalization of case or further directives.
Your lordship.
So there is no directive. The case has been finalized.
Your lordship. On 15 July, your lordship.
The directive, see. What the further directives from the High Court? There is further directive.
Exactly, my lord.
So does it mean that for eternity?
I can't wait till eternity.
So they don't want to work. Your client is not interested in work. No one has stopped you.
The work is to be executed, my lord, with humble submission in presence of authority. The authority, my employer, They say not to start the work till directive, my lord.
Where?
Your lordship, annexure 1, I am again placing your lordship.
Sure, one to you.
Not to start the work till finalization of the, kindly date, my lord, my humble submission. Date, your lordship, is 31st July 2024, when there is no more case pending before this honorable court. Lord, thank you. Otherwise, I.
He is mischievous. The petitioner is mischievous. He doesn't want to do work, and on the ground of this communication.
No, my lord,
Huh? Huh? No, don't start work till finalization. So he knows that the case has been disposed of.
Further directives. Further directives actually made.
Further directives of Odisha High Court. So Odisha High Court, why the Odisha High Court will?
I undertake to complete within time, your lordship.
No,
I undertake.
Were you are playing mischief.
My lord, I have a agreement, my lord. I have a not party, my lord. I have said package was not subject, humble submission. Said package was not in the subject matter of the writ petition. Your lordship made some observation, confirm the disqualification. They, without hearing to me, when the agreement was executed, they tried to stop the work. My agreement was kept up.
Mr. Counsel, the moment you received this communication, you could have told them that the writ petition has been disposed of and there is no further direction.
Already, my lord. Your lordship, with mail, your lord, proof, your lordship.
Everything is there on record.
Annexure 10,
but you are not executing your work.
This, unless this is stopped, your lordship, annexure 1, your lordship.
All right. So these are only two annexures.
Pardon?
These are only two annexures.
Annexure 10 means my.
Who has issued the order?
Sorry.
Who has issued the letter?
My lord, the executive engineer, my lord, now.
No, chief construction.
My lord.
Chief construction engineer.
Let executive engineer, rural works division, Noapada, join online tomorrow. Let this case tomorrow be taken up as the first case. Yes, ask him. Give a copy.
So to Malawan, today, just now I am serving.
Then why are you making submissions?
No, already, my lord, solved the mill.
Copy, sir.
No, man. Lord, I'll
No,
submit.
what he says, otherwise it would not have been listed.
Number of your lordship, this could not be numbered, your lordship. The process.
All right, let us see.
Your lordship.
Not hai.
Let us see whom you have added as a party. If otherwise, for that reason, you may not have served copy. You have
Your lordship.
State of Orissa is there, so you should have.
Just checking the mail, unless lordship. I'm just.
Column 6 says not filed. 6.
No, I'm just in email we are submitting, Miller. I'm just Miller.
We will give you half an hour time to tell us whether you have served copy or not.
The check report says not filed. No.
I'm extremely sorry, Miller. For
No. This is not done. It's misconduct.
If you have sent by email, you must be having some document with you. If you're so anxious about your case, why did you not
I'm extremely sorry. This is too
verify?
Please be careful
I'm extremely sorry.
when making your submissions before the court.
Just 1
Miller,
minute.
I have a Miller proof, lordship.
Just 1 minute.
Sorry,
so
Miller,
it
I have-
says objection is copy not filed. So when did you serve the copy?
Miller,
now?
the
Tell us.
copies of 28, Miller, as per my email to the Honorable Learned Advocate General of 28 August 2024, your lordship.
28.
Your lordship, I have a mobile also.
When did you file your writ petition?
Miller, same day, 27th August, your lordship.
No, there is a defect.
Your lordship, kindly have a Miller, kindly verify.
That must have been cured.
Your lordship.
He has to give you a hard copy, man.
I have a proof, but I authorize.
Are you required to serve a hard copy also?
E-copy, Miller, e-filing,
E-copy.
paperless.
E-copy. How will serve e-copy to the office of the Advocate General?
Why you will download?
No, he has to give a hard copy, man.
Then what is the use of e-filing if he has to give hard copy to you?
Always I am submitting e-copy, your lordship.
Why will he give hard copy? This is the whole object of e-filing, that no hard copies will be given.
All copies serving through email. Miller. All my petitions are serving email, your lordship.
Already you serve one extra copy.
I'll today, my lordship.
You have to get from your office. From
No, yeah. The practice is that we are receiving the hard copy. Thereafter, we are.
Thereafter you are scanning and keeping.
Miller, I'll serve hard.
The whole object of e-filing goes if he has to serve hard copy.
All right, we'll see. Tomorrow.
We'll examine it, let him serve a copy. But I think your office not able
And
to
please
cope up.
examine what is the nature of the communication which has been made after disposal of the writ petition.
Because unless they are inquiring into it, this makes no sense. We have disposed of the application. If they are making some inquiry, one can understand. Without that, what is this?
Hello.
Item 15.
So take up this matter tomorrow.
Tomorrow, 10:30. You should ask him to explain the circumstance, Mr. Anti. You should ask him to explain the circumstance in which the letter has been, that letter has been issued and he has been asked to not to work.
Right.
Your Lordships, the initial contempt was filed against a judgment of this court, for non-implementation, which your Lordships will find at Annexure 1, page 44. Page 44, page 44, your Lordship. You'll find it page 44. May I take your Lordships to the relevant page? The operative portion.
Page 44.
44.
But then he was punished or he was not?
No, your Lordships. I'll explain that.
No, because this appeal will only be maintainable if he has been punished.
No, your Lordships. The contempt was dropped. Against the dropping order, we have.
No, that is not maintained.
19 will say this. With the order, decision of a single judge. Your Lordships, but we do have a provision of appeal.
That is the law which has been already.
An appeal shall lie to the right from the order or decision of a court, High Court, in exercise of its jurisdiction to punish for contempt. That's the reason. Punish for contempt. May your Lordships may just keep it for tomorrow. We'll examine it a little more.
There is a Supreme Court decision on this.
Lordships, may I just verify myself?
All right.
I definitely slipped this, so that's the reason. Monday, if your Lordships will permit.
You can argue that the contempt proceeding has been dropped in exercise of jurisdiction to punish for contempt.
That's the reason why I
This is the argument which you are going to advance tomorrow.
Not tomorrow, your Lordships, keep it on Monday. I'm not there.
All it as requested on behalf of the petitioner is this matter on Monday. Yes.
Item 16.
That's item number 16. So also can look order has been complied with. The Tahsildar has passed an order yesterday for correction of record of right and issue pota in his favor. This is the order.
Complied with.
Pota not issued till today, man. Pota not issued.
Yesterday order is, may I read out, the record keeper is directed to correct the record of right in favor of the petitioner Sri Prasanth Kumar Rautray in the above scheduled land. So yesterday this order was passed. Record keeper will issue the ROR 1 or 2 days.
You should be happy, Mr.
One copy maybe some.
We can see a smile on your face with the compliance of the court's order. Yes.
I'll give a copy. No problem. I'll give a copy.
Yes.
Orders item 17.
Item 17, my lord, is if my lord see the last order, it says that it should be listed with the connected matters, my lord. OMC
Here, my lord, this has been listed on my mention. On my mention, I have filed an IA that is at flag C, 11350 of 2022. Here I am the subsequent lessee of the mining lease area in question. And now I have been alerted with the lease in question. Because of the dispute between the state and the petitioner, now I am not able to proceed with the mining operation because huge stack of iron ores are stacked over the mining bearing areas.
In fact, my prayer is, my lord, that it should be removed. He is also making same thing that it should be removed. Myself and OMC are together that it should be removed. The state is opposing. 6 writ petitions are pending on similar issue. If my lord see the last order, last but one order, 13/11/2023.
No, that is on the merit of the matter.
6
merit of the matter as to
6 matters
of the minerals. That is on the merit of the.
And who will be allowed to remove?
Yes.
No, that is who will be the beneficiary of the ores.
So who will be entitled to remove and enjoy?
Yes, but for the time being, here I have filed the IA because of this stacking of the ores in the mineral bearing. I am not able to carry out the mining operation. My mining operation has come to a standstill position now.
So either state makes a separate arrangement for stacking or allows it to him. So it is onus is on the state.
Yes.
Yes. Because a storage of this quantity of mineral requires 24 hectares of land. So it's not that something I can carry and keep it in my
It's
house.
lying in open space, degrading day by day.
In fact, my petition is that I should be allowed to remove. State is contesting that petition, my lord, and 6 petitions are listed. So
It's allowing permission to remove those were being done, I think, years back. Why is this still there?
Well, his application
order was passed, my lord, on 22nd December 2020 that authorities should consider a representation and decide on case-to-case basis. Authority again rejected, saying that no, we will not allow you. And then we filed the writ petition.
because of 12 HH, the condition stipulated in the
In a very
mineral
mechanical
concession
manner.
rule, 12 HH was not allowed. Now the IA has been filed by the OMC. My Lund AGA is there. AG is there, my lord.
Yes,
See.
But I'm sorry, I may be permitted to say.
Yes, sir.
But this has come for orders today. The IA Milord at flag C, your lordship may kindly peruse. Actually, after the expiry of the lease period, since Milord 2020, after the amendment of the MMDR Act, this has been, the lease has been allotted to given to Orissa Mining Corporation, which is a state-owned PSU. That the moratorium period is 6 months for removal of these stacked minerals along with the machineries. Actually, my lord, the petition was filed in 2021 with a prayer. Your lordship may kindly look at prayer number 5, Roman 5. But he says that 6 months period may be granted for removal of the stacked minerals along with the machineries. So not more than 3.5 years have elapsed. This IA we have filed, he had prayed for 6 months more time because the statute provides for 6 months time for removal. During the COVID time in that Goa Foundation case, lordship remembers they were granted 6 months more time. And after that, a batch of writ petitions came to be filed before this honorable court, and the petitions were disposed of with a direction to the state government to consider their representations. All those representations were rejected by a reasoned order, which they have impugned here in this writ petition. But this IA has been filed with a very specific prayer, because the quality of the minerals would be degraded. There would be decay because 3.5 years have passed, and there is also obstruction for the mining corporation to carry out the mining operations. So we have prayed that let it be sold, auctioned, and the money be kept in an interest-bearing account, so that if either party will not wins or loses, then that would be paid to them. There is no question of keeping this. So therefore, this IA Millard at flag C, your lordship may kindly look at our prayer. Flag C.
When did you file?
Millard, this has common mention. We have filed recently.
When did you file your application?
Flag C.
2022.
Flag C, your lordship would file. That is at flag C.
22nd August 2022.
My lord. But this has a very specific prayer. It appears to be reasonable.
My lord, last order says that.
Just a minute. But in the facts and let's say
Flag C, Mr. Acharya, flag C has been filed by the OMC.
Yes,
by the OMC. Milord, I am representing the government.
You are for the OMC.
OMC.
And state government who is representing?
State has no objection. They received the
State has
instruction.
given the instruction.
State has to auction, not OMC. OMC is a subsequent lessee.
That is, the state has no objection. I think they have received the instruction. We have received the instruction.
You are representing whom, Mr. Acharya?
I am representing here, Milord, the PSU, Milord, Mining Corporation.
OP number 3.
May be difficult for you to represent. It may be difficult for you, Mr. Acharya, to represent the corporation because
there may be conflict of interest between the estate
No,
and.
there is no conflict of interest, my lord.
There is no conflict of
No, my
interest.
lord.
No,
They
no,
have
no.
given
There
this
is no, I
instruction.
have examined that, so therefore there is no conflict of interest. The state has given it to OMC, it's a state-owned PSU, there is no conflict of interest. State has also not given instruction that the previous AG was also appearing here in this case. It's a state-owned PSU.
No, that is different. There may be dispute between the estate and estate-owned PSU.
There is no here, there is no conflict of interest.
So Acharya, the prayer of OMC is to vacate the land. You are talking of auction. So auction
Similar
is
to
not going to
vacate
be
the-
conducted by the OMC.
Similar to vacate the land, in fact, the state has given, your lordship, a place to pass appropriate directing to vacate the mineral bearing areas over which the excavated minerals plant of this so and so. But the proposal we had given in for
Acharya, you think over this position again. You are a lessee, and the estate
Lessee.
is the lesser.
Correct.
So whether you will appear for the lessee or lesser.
Lesser, in fact, had to file this. Your lordship is correct. The lesser has to, because the
Think over and
let it come. Actually, I am outside Orissa. Let it come. Yes, today in the morning I obtained the instruction.
Please come.
May I suggest, my lord, the other, all writ petitions may be listed.
No, that is
And
on
it
the
can be
merit of-
decided, my lord.
I am concerned so far as my.
2021 writ petition, why to keep pending, my lord? Every time the court has
Because
passed
of-
order.
Because since all these matters were tagged up.
The prayer was to vacate the land within 6 months.
In this matter only I have filed the
I am agreeable to that prayer. I want to vacate.
We will take up all the matters.
My lord, I am agreeable to this prayer. I want to vacate. I want to take away my mineral. They are not allowing. A state is not allowing.
How their prayer is not there allowing allowing you to take away. They are saying let us auction keep it and then it may be decided who will get it.
It should be vacated. I want to take it out. OMC wants
for the OP number
vacate it. Only a state is opposing.
My learned senior is leading me.
Let it be, let all the petitions, similar petitions be listed on one day, any day next week or.
What are those cases? What are those matters?
My lord, the order dated 13 November 23 of my case
that
has given detail of all the cases, my lord. 6 writ petitions are there. 13 November 2023 order, if my lord sees, detail of all writ petitions are there. My lord is having that 13 November 2023 order passed in this case only.
Yes.
On top, all writ petition numbers are given and then name of parties are also given.
Oh, once they were all listed together.
Yes. Only because of mentioning it has come separately.
So and so, this matter along with order dated WPC so and so for admission on when?
Next week
Next week, my lord.
Coming on 11th.
1 week after Milan, not next.
11th, I am coming, my lord, if my lord is.
11th.
Deeply.
We taken up at PM.
May I please? So my input order is at phase 13. One formal, annexure 1.
So this is come for the condonation of delay.
Delay,
my lord, 582 days. 582 days delay, my lord.
582.
My lord.
What is the matter about?
Not 500, but if that COVID period will be deducted, my lord, that very small matter, my lord.
COVID period is deducted how much? 200 something?
Yes, ma'am.
Or less?
Yes.
How much?
It was filed on 2023. So from June 2022 to the 300. 300 days. A very small matter, my lordship, page 14. Paragraph 4, I am reading, my lord. Be that as it may, while allowing this writ petition, this court directs the appropriate authority opposite parties to grant the benefit of RSCP at the rate 6,600 with effect from 8/6/2015 in favor of the petitioner by undertaking the interaction within a period of 2 weeks from the date of communication of this order. This was the direction, my lord. Your lordship, I draw my lord's notice only 2 dates. It was appointed on 9/8/86.
But is that first, what is stated in the first paragraph, that you will only grant it to persons who obtain orders from the court?
So that is not the ground in that writ petition. I will come to that.
Okay.
Your lordship, for a moment, your lordship, say one date. 9/8, your lordship, first date of appointment is 9/8/86. In my date chart, your lordship,
Your date.
yes, ma'am. 9/8/86. List of dates, your lordship can find it. Was engaged as a supervisor. So admitted fact was appointed on 9/8/86. That is not disputed.
But
I'm
you
coming.
will have to pay.
Hello?
We can condone delay only if you pay.
Yes, my lordship. But this is the here my your
lordship will see the limitation petition, my lord. So for the COVID period has not been mentioned.
Forget anything. Whether you are entitled to or not is the most fundamental aspect.
My lord.
The order was passed on 19/8/2021.
My lord.
When had you filed your writ petition?
24 April, my lord. 23.
24 appeal. On the first day, without any affidavit, the order was passed.
My lord.
So had there been affidavit filed on behalf of the estate, the matter might have been different. So this is a ground for interference. And now he is taking, the matter would have been different had all the facts been admitted. But he is saying that you are not entitled to.
No, my lord. So far I am entitled. So far the present respondent number 1 is concerned, my lord. She has completed 30 years service. As per the government scheme, my lord, the person who has completed 30 years service, she or he.
All right. According to you, you are entitled to.
My lord.
According to him, you are not entitled to.
My lord.
This is a dispute.
My lord, so far the dispute, my lord, so far the government notification is concerned, my lord, that is prospective in nature, my lord.
Mr. Please appreciate this.
My lord, my
you
lord.
may be right in your contention. We may dismiss the writ petition on merits, but we will have to consider the merits.
My lord.
That is the question. There is delay. You are right. Long delay. We accept. But therefore, we are imposing cost for condonation of delay because there is some dispute which requires adjudication. All right.
So far the limitation petition is concerned, my lord.
Simple thing, my lord. What he is saying.
May I submit my one thing, my lord? So far the limitation petition filed by the appellant, he has categorically stated that delay was caused due to official procedure.
So therefore, we are directing them to pay cost. All right. How much do you want?
No, my lord, I cannot say, your lordship.
No, you also say something.
You can suggest some amount.
Let us see what is.
My lord, I am unable to say, my lord. Your lordship to impose 1 rupee or 10 rupees.
No, you suggest. What was the fee charged by you?
My lord, I am unable to say, my lord. Your lordship impose any
What
cost.
was the fee charged by you? This you should disclose.
In open court, I
don't disclose.
Okay, no.
My subject to payment of 5,000 cost.
No, 20,000.
My lord, very
20,000, sir. It's a gross case.
If you cannot write, take proper grounds, you have to pay cost.
No, normally I don't bargain, my lord, because your lord, it is up to my lords because that is admitted fact there is a delay. Lords,
All right, 15,000. 15,000.
My lord.
Payable to the petitioner.
My lord.
We
Within,
are delaying,
within,
condoning the delay.
Within
582 days, my lord.
We are condoning the delay, subject to payment of 15,000, and we will hear the writ appeal on merit. When?
My lord.
When do we want?
No, your lordship fix.
Okay.
payment within 2 weeks, sir.
Is this matter?
3 weeks.
3 weeks. 3 weeks.
My lord.
So 3, 1, 2, 3, 24. You come up on 24/9/2024.
My lord.
Have you received a copy of the writ appeal?
Yes, my lord.
Copy of the writ appeal has been received by learned counsel for the response. Yes.
I have received application of stay petition. I want to file an objection.
Item 19,
already argument over order was here, but wrongly it was written for orders.
Yes, don't get worried. Don't get agitated.
Your lordship appoint to direct the for fresh tender, my lord.
What?
For fresh tender, your lordship shall appoint on that date.
No,
Order was
No,
rejected.
opinions can change.
No,
order has been passed.
though I am successful tender, but due to stay of single bench,
The 1 week. Yes.
Reserve, my lord.
Yes. We will come after only.
My lord, only that question only your lordship is to adjudicate with the before your lordship that whether but the rejection of technical bid, the region assigned is illegal and valid, my lord, in tender matter, my lord. That is the only question, my lord. I have filed the affidavit pursuant to your lordship's guidance. Lordship is to decide. Oblige.
May I pray this matter may be taken up day after tomorrow.
Day after tomorrow, I am sorry, my lord. Maybe tomorrow or sometime next week.
Tomorrow
also. Tomorrow. Next week, next week. Day after tomorrow, I am not available. I'll go somewhere.
What is this matter about?
That nursing matter, my lord, arising out of contempt, the writ appeal, they took time twice or thrice saying that settle the matter.
Oh, that is why it was.
That is why the
1 week, as you had requested.
After launch,
1 week enough to settle?
yes, my lord. Today I'll get the instruction after
All
launch.
right.
So for that reason, I was saying after day after.
Item number 21.
Like 21 days delay in filing present appeal. Sorry, 54 days. 50 per day delay in filing the appeal.
Notice has somebody is appearing or notice has
No,
to be
notice
issued?
has to.
IA
IA number.
IA number 4775 of 2024.
Yes, sure.
The issue, this application has been filed for condonation of delay of 54 days in filing the writ of appeal. Issue notice. How many opposite parties?
My lord.
State of Orissa. Okay. So you have to take notice on 2 and 3.
3 only. 1 to the state will represent.
Okay. Issue notice to the to 1 and 2 also. Accept notice. State of Orissa and CDMO. Issue notice to the opposite parties on the question of condonation of on the question of limitation. Full stop. Notice on behalf of opposite party respondent. The opposite party number 1 and 2 is accepted by Mr. Saswat Das, learned additional government advocate. Necessary 2 copies of the IA be served on him within by 6/9/2024. Requisites for issue of notice on opposite party number 3 by registered post / speed post be filed by 3 days. By 6/9/2024, notice be made returnable within 4 weeks. List the case after 6 weeks. This
Will
one,
come on 9th.
ninth.
Only one prayer. In the last occasion, in the ordering portion, it has been stated that DP Nanda Senior Worker along with Mr. Ranjan Kumar Biswal, I am appearing for opposite party number 4 and 6, and Mr. Nanda is appearing for opposite number 5.
All right, that will be corrected.
On 9th, Lordship.
Mr. Nanda is for OP5.
Yes, madam.
You are for 6 and
4 and 6.
4 and 6. Mr. Dale, your notes there file, please scan it and give.
On 9th, madam.
Yes.
Note 23.
And keep.
My lord, requisite has already filed. Requisite has already been filed to opposite party number 6.
When did you file, madam? When did you file?
Today only.
Today. What is your name, please?
Jayanti Das.
Jayanti Das. Miss Jayanti Das.
I am on behalf of Sanjay Kumar.
No, you. I think you have signed the Wakalatnama. Your name appears. Please see. Miss Jayanti Das, Learned Counsel, appearing on behalf of the petitioner, submits that requisites have already been filed. Yes, you have signed the Wakalatnama. Requisites have already been filed today. Is there any interim order?
No.
Is there any interim order? No. Since requisites have been filed, notice may be issued to the opposite parties. Where is that? Notice may be issued to opposite party number 6, making it returnable within 4 weeks. List the case on. Four weeks, only 6 weeks. 6 weeks, please give a date.
Well, 22nd October.
22nd, it will be listed on 22nd 10/2024. All right. File today. File today are accepted if you notice.
Item number 25.
May I please, your lordship?
25, I am appearing for the opposite party OSFC.
Ma'am, I'll just briefly point out a few things, my lord. And this is a case where, my lord, the grievance was with regard to recalling of the loan liability and consequential action. And in the writ petition, the petitioner essentially wanted to say that the amount that was sought by the petitioner were not released in due time, for which reason, my lord, all these things happened and ultimately recall of loan liability was done and therefore the action was challenged. I beg to draw your lordship's attention only to 2 orders of this noble court, order dated 30/10/2007 and 27/11/2007. Man, this noble court.
Yes, we are reading. We are reading that order.
I'm sorry.
Yes.
I was told by my friend, my lord, nowadays the OSFC is not providing any finance. It is virtually defunct. They are only, my lord, recovering the loan dues that are default. I am subject to your lordship's kind consideration. May I only pray I'll approach the authorities for consideration of my grievance. If this not, your lordship will kindly consider, because there is no question of grant of any loan by them, because I think they are not that is not anymore functioning that way, but they have virtually stopped transactions except the recovering the amount which are due to the OSFC. Subject to what my friend is also appearing, he will apprise your lordship.
That is instruction.
But what had happened 17 years back when you had been given that opportunity or chance? Then they were giving, I think.
Then they were giving, my lord. But now in the meanwhile, my lord, despite my effort, I have not been able to get up-to-date instruction regarding the position, my lord. That is the whole difficulty, my lord.
And senior counsel appearing on behalf of the petitioner submits that in view of the changed circumstances, he may be permitted to withdraw the present application with any liberty.
My lord, I am praying for that liberty to move the authorities, my lord, for consideration of my grievance.
With a liberty to approach BSFC.
OSFC. Orissa State Financial Corporation.
For a resolution of the dispute. So this application is dismissed as withdrawn with the liberty as sought. Fair notice.
Grateful, my lord. Grateful, my lord.
I am appearing for lawsuit.
Item number 26.
Yes.
Input order is at Annexure 6.
Annexure 6.
Page 24.
Yes. What is the order?
The order of the State Administrative Tribunal. I have given that legible copy of that.
You given legible copy of what?
That Annexure 6.
It's legible. Page 24. Type copy is there.
Yes. What is the dispute?
The dispute my lord, that were taken over by the government from this particular date. The learned tribunal had granted the benefit throughout the service. He was not in the government service, and he received the pension and other benefits. After 8 years of the receipt of that pension, he approached the learned tribunal in 2003 that my entire service period is to be counted for the purpose of pension. He entered into service on 18/7/52. The school was taken over with effect from 1989. He retired on 34th, 1994. In this case, someone has appeared.
Who is appearing?
Someone has, Mr. Patnaik, Prasanna Kumar Patnaik has appeared.
Can you inform him?
Yes, I'll last occasion he was here, he requested me that just now he's not available.
No, today was he there?
No, not today.
Last date.
Last date. This is a old matter. If your lordship can fix it to Thursday, I'll inform him.
Presentation on behalf of the respondent. Since it is an old matter, list this matter on Thursday.
I'll inform him.
So we make it clear that the court shall proceed adjudicating upon the dispute even if there is no representation on behalf of the respondent, opposite party.
Yes, my lord, opposite party.
Contesting opposite party upon whom the notice has been validly served and he has entered appearance by file by way of wakalatnama. You wanted an
My lord, I wanted a short accommodation, my lord. I have taken consent from the appellant counsel, my lord. He is also present. Matters are being in item 29, my lord. You have, my lord. Next one.
yes,
Item 4.
Yes.
We also serve it counter your filing.
Let us begin.
You must have your filing.
You will be filing your affidavits in the meanwhile. Let us start. Because every day the matter is being adjourned for one reason or the other. Let us start.
May I assist your lordships in this matter, my lords? Already divisional bench has already passed judgment, my lords, in favoring all the writ appellants, my lords, renewing the license for on the next 5 years, my lords. That matter is now pending for the Supreme Court in SLP, my lords, so referred by the state. No stay has been granted, my lords. So the division was, my lord, Justice Rath is also party, along with the Chief Justice, Justice Talabatra, my lords. That I have given my lords in my compilation. I am passing.
Must have filed the soft copy.
The judgment, that's what happens.
No, have you filed it with your compilation or?
Yes, and today I am filing the
Today.
judgment I am giving. The judgment of my lord.
Page.
Page, my lord.
$76 or 40?
Yeah, 102, 102, my lord.
102? That is Supreme Court's order. I'm saying High Court order 71. Okay, got it.
Page 70.
71, single judge.
You are referring to this one? Supreme Court. No, all the division bench.
Where is the division bench order?
My lord, I am giving.
Single bench order is here.
Yes.
Writ appeal.
Yes, read up.
103.
Yes, ma'am. 103. 103, ma'am. Paragraph 13, my lords.
Just a minute.
One bit.
But that was different. That is entirely different.
No, man. Paragraph 9 minors calculation C. The 27th February 2015 letter is in the crux minors. On basis of which minors, the state realized this letter only. They say that we will not renew for the lease minors. This is the only letter which has been challenged by all these writ appellants.
All right, are you appearing in the first case?
No, I'm not appearing the first case. I'm just bringing the notice for this.
All right, you have brought that to our notice.
Man. First case.
Yes, who is appearing in the first case? Or who will lead the argument?
I'm appearing the first case, but this is an understanding that one of us have to lead.
Who will argue? You will argue.
I can argue. Who will support?
Yes, what is under challenge?
But if your lordship looks at my writ application, that is appeal 1127 of 2024.
One, 2, 7.
Yes, my lord. Writ appeal 1127 of 2024.
Yes, sir.
Yeah. Yes. Very good. Yes.
But precisely, I would like to bring your lordship's notice. There was a government circular of the government.
Let us come to the order first.
Improved order, my lord.
Yes.
But with due respect, can I just explain one thing? Order, if your lordship looks at the way the court has dealt with the matter, honorable single judge, nothing wrong about the...
No, just for the purpose.
Yes,
of
yes,
how to
absolutely,
treat,
absolutely
just
correct.
For that purpose.
I'll take your lordship. So kindly turn to the impugned order, annexure 9.
Annexure 9.
9. Page 93. my lord.
Yeah.
In fact, it starts from 95. All those batch of cases were taken up together. And eventually the order is delivered in one of such cases. It starts from page 100. 100.
You are addressing on which case?
I'm appearing for one of the
No, which is the case number? Writ appeal?
serial number.
Writ appeal.
Writ appeal is 1127 of 2024.
All right.
Though the effect is the same, but my case stands in a different footing altogether. Reason being, I have a license in 2000. The policy decision of the government was of 83. 83 policy decision has been renewed from time to time, where the government thought it appropriate to have day and night sub.
No, there is a difference between license under the provisions of the Act and your status as a lessee. There are two things.
Right.
So both the things cannot be clubbed together. You can have a license if you have the lease, but you don't have the lease, you can't get the license.
The license is granted by drugs and control authorities.
Therefore,
right. There it is mentioned,
if you can show that you have got a place to operate, and they say it's not your own property, then you should take it lease or license for more than 5 years. Minimum is 5 years.
So
If I were to-
therefore, the license is, you are challenging refusal of license or?
No, sir, we are challenging the lease that was
Therefore,
right.
Therefore, we.
Non-extension of the
observation.
right. So if that is extended, obviously the license will also be extended.
So that is the issue.
That is the issue, my lord.
Yes. Yes.
The interesting, the ground on which actually they say we are not going to extend the period of license or lease, whatever they call it, my lord, because we are having a Niramaya scheme.
All right. Let us remove because then.
Then not the question arises, discretion of the government to extend or not. I'm on that, my lord, to be fair, or so far the legal point is concerned. But the discretion has to be used with a judicial mind and appropriate way. It must be reasonable. Nexus with the public
It's
interest.
not a question of discretion. It's a question of policy. So if
with due respect, my lord, there is no policy not to extend.
All right. All right. Let us see.
There is no policy. The Niramaya policy doesn't say it has to stop extension of license. No, it doesn't contain anything, my lord. If you also look at the government counter also, they have filed all those policy part. We are not objecting to that. To be very precise, my lord, we are not objecting to Niramaya scheme.
No.
We are not objecting.
The policy of not extending. Therefore, we
No
object
policy,
that
no
let us-
policy.
Let us forget that because. All right. The lessor has a right
Yes,
to extend the lease or not to extend.
not to extend.
If they have taken a policy decision,
Right,
or if they are doing it,
right,
if they are declining to extend,
correct.
then whether the court should direct them that no, you will have to extend.
With due respect, my lord, court has got the power. If it is unreasonable, basing without any justifiable reason, they are trying to stop it.
All right. Yes, let us see the single judges.
If you also look at
Reasoning.
the impugned order,
Yes.
it's as page 100, my lord.
Yes.
Factual matrix is mentioned at paragraph 3. It's a government of Orissa issued resolution, office order, all the series of dates are there, prescribing guidelines and further revising them for opening 24-hour on-campus medicine store in government medical college and hospital, in district headquarter hospitals and subdivisional district headquarter hospitals and CSs, all those hospitals. A perusal of the aforesaid resolutions leads to the court to the following salient terms. A, that is very relevant, my lord. 24-hour on-campus medicine stores are permitted to be opened in government medical college hospital, so and so on a license basis at different point of time to different parties, many of whom are currently parties before this court. Over time, the duration of license term has undergone modifications, culminating in the latest revision of guidelines on 1/7/2013, which sets the duration at 5 years. The renewal of license upon its expiration is contingent upon the assessment of both public necessity and performance of the licensee. On-campus medicine stores would be allocated temporary premises for erecting provisional structure, of course at our cost, for which the licensee would be granted a provisional right of occupancy. The licensee must dismantle the said structure upon 1 month's notice from the licensor. Priority for on-campus medicine store license shall be accorded to unemployed registered pharmacists. In their absence, license may be granted to individuals who commit to employ registered pharmacists on a full-time basis. 30% of this license shall be reserved for female candidates, with male candidates eligible in the event no female candidate coming forward. The petitioner currently for the court represents few of the many licenses who have been managing on-campus medicine stores
No,
with
why are you
government
reading
medical
everything?
college hospital.
Why are you reading the entire judgment? So what is wrong with the judgment?
So Honorable Court thought, with due respect, Lord, that we are challenging Niramaya scheme. We are challenging opening up the free medical store. Actually, that is not the case.
All right, let us forget that. Then what is the...
That's the reason why Honorable Court tried to discuss and dissect the point, legal point, whether it's a license or a lease, whether we have a legitimate right to operate or not, whether it should be extended or not. Everything keeping in view the fact it's a government policy to stop it. So government policy as per the university doesn't stop it. It doesn't say that no, a day and night medicine shop will not operate. On the other hand,
All right, where is your shop located?
my shop
Where is your shop located?
locates
Yes.
inside the premises of the hospital.
Which hospital?
District headquarters.
It's Baleswar,
Baleswar.
Baleswar District Headquarters Hospital.
So how many shops are there?
One.
One.
I have got one that was also as per the Supreme Court direction. Actually, what happened in this case, 2000 I got it. The license was got in 2000. So the lease of the property, I was allowed to operate it. The license could not be granted. Then I challenged it. Then one of the person, actually my allotment was challenged by another lady. She says, no, I should be allotted. The High Court said, eventually, no, it has to be allotted in my favor. I continued thereafter. They delayed in giving it. So I filed a writ application. So eventually in 2000, I got it, continuing as such, and I'm paying the license fee and everything. The policy is modified from time to time. I have adhered to the modification terms and condition. 2013, the latest guideline, as per the policy, old policy, still in subsistence. That policy has not been changed or it has been taken away.
Yes.
It has not been repealed. It has not been withdrawn. So if that policy remains, and if you also looks, one of the Supreme Court decision, 95
No,
Supreme Court,
why did you go to the Supreme Court?
Supreme Court, another person actually challenged my license.
Yes,
So High Court passed an order that
in
was
your
challenged.
favor.
So there has Supreme Court set aside the order.
No. So then who went to the Supreme Court?
Who has?
Then who went to the Supreme Court?
I went to Supreme Court.
Because High Court said that
succeeded.
the other person is entitled
Right.
to get.
I
All right.
succeeded, not remanded. High Court then granted in my favor. I am continuing since as per the order of the High Court.
And I'm still not able to understand. If you are continuing as per the order of the High Court, why did you go
So-
to the Supreme Court?
So actually what I mean to say,
Yes.
my continuance is since 2000 because there was a previous litigation relating to my continuing here because the other person wanted to continue here. And the license was not granted, delayed, so I filed a writ. So all those things are not the subject matter to be adjudicated here. This is a factual aspect, I say, the basis on which I continue, my lord. And I have been granted a valid license by the drug authorities. I have been granted the lease. It has been extended from time to time. Since 2000, and it is continuing till 2021. My application is still pending. I have given the detailed fact in my writ also. But what I wanted to say, that policy of the government has not been repealed. It is still in vogue.
All right. So where is your lease? Lease deed? Or whatever document, any agreement.
My file was released. Annexure. Annexure 2, Lordship, kindly see. Just- It is the license.
So you said there is only one, there are
Ah.
two.
If your lordship looks at Annexure 2 is my diploma certificate.
No, annexure one.
Allotment is Annexure 1, 29/1/2000.
Now come to annexure one.
Yes, page 45.
Annexure one, your shop is the second 24-hour medicine store.
So the person
not the
actually who filed a writ application, he wanted I should not be there. So I continued. I don't know. I can't say just now whether the other one is still continuing or not. It's not there. And his shop is not there. The other person's shop is not there. At page 47, if you also look, that's the pharmacy certificate as required under law I had to give. Certificate of trade licenses, page 48. The government doesn't dispute all these things, Marat. Now the question is whether that policy is subsisting.
All right, where is the agreement?
All right, here, let me kindly take note of a fact that in 95, on the basis of this, actually, an on-campus store was opened. The outside medical people, the stores, they actually challenged for the Honorable High Court. Nobody should be. So that was.
We have first to consider your right. Just see, we are proceeding step by step. We have seen the order passed by the learned single judge. You have introduced the regions assigned by the learned single judge for rejecting the claims. Now we have brought us to Annexure 1, which is the decision of the government of Odisha for opening second 24-hour medicine.
24-hour.
So under this order or decision, you were given the...
Yes.
Please come to Annexure 1.
Annexure 1. Well,
so you were required to execute an agreement. You are degree.
Yes.
To execute an agreement 2-1 and 2-2.
Execute an agreement in the prescribed form for 5 years, copy of which I will send to you in this office order 6/12/96.
So where is that agreement?
But that I have to file because
It is very difficult. Your whole right depends on the agreement. The entire right depends on the agreement. So the agreement must have been there in the writ petition.
But if your
agreement is not there, then we will locate the order of stay.
So all those previous writ applications filed, because filed in that
Mr. Mishra, your right to carry on business depends on the nature of agreement which you had entered into.
You filed an agreement.
According to you, the agreement was not there.
No, agreement is there.
Where is that?
No, I have not filed it.
You have not filed it, then
just
the question of interim. Writ petition Annexure 5, it seems it is there.
In the writ achi. So I'll just check up once, madam. I think it must be there in the writ application. I'll just check up 1 second.
Yes, Annexure 5.
It's a renewal one. Renewal.
My lord, I may interrupt, my lord. I think 2013, that is a standardized for all the shopkeepers for 5 years. That is a decision of the government. That is in my brief, the license fee for entire 5 years are to be deposited in 2 installments. This is for everybody.
We are trying to understand the nature of arrangement between you and the government.
Right. That is for everybody 5 years.
So clause 11 says 5 years.
Right.
No, without, sir, 5 years has to be the minimum. The reason being the license cannot be granted by the drug control authority.
So unless you have a lease for 5 years, they will not grant the license.
Not grant license.
So, all right. So this was for 5 years. Made wide honorable verdict. And then it is 20. This agreement is wide decision dated WPC number.
Sir, 37, page 37 in the writ application, my lord. I think the agreement is there. As an annexation. It's a last agreement. In the REIT application, WPC 1632 of 2021, it is Annexure 5, page 37.
Yes.
That is the agreement. Last agreement.
Yes.
That's a deep one, you know. Main file of
So what was the period of lease?
5 years.
Where is that mentioned?
Clause 16.
11.
Last clause. 2004 policy. I think it must be in the last clause, Mara. Clause number 16. Somebody give this, somebody.
So in view of clause 11, what right do you have?
So I have indicated before, Lordship, the legal right flows out of this agreement, but the question arises, they have the authority to cancel it. Or
No cancellation.
Or determine it.
No termination.
Not been renewed thereafter.
No termination. Read clause 11.
11. So that this, I think it starts with that the lessee is hereby given permission to open 24-hour medicine and drugstore for a period of not exceeding 1 year from the date of execution of this deed. No such permission will be given unless
1
year.
5 years. 1 year. What are you reading? What are you reading?
No, it actually is. This is not my agreement, in fact. I think it's a format.
We are reading your agreement.
Clause 16 is there. This says that within 1 year you just open.
Clause 11, which is part of that agreement, that says 5 years.
Yeah. The clause, our clause says 16 says it is 5 years.
Yes. His clause 11 says 5 years, page
No,
40.
5 years.
All right. So let us understand.
Right.
What right do you have? And your right is based on the agreement.
Right.
Nothing beyond that.
Right is based on the
So
agreement.
what right do you have to get the your period extended beyond the period prescribed in 11?
So the reason being, with due respect, Melody, the policy
I
says.
always with due respect, Mr. Mishra.
So the policy says it should be 5 years.
Yes.
Right. Policy says day and night shop has to be opened in the premises in question. Policy says anybody who wants to open, he has to invest. Policy says you should comply with the requirements of the policy itself.
Policy says that it cannot be extended beyond 5 years. That is the term. That is the
Right.
arrangement between you and the government.
Sir, and policy says that the 5 years granted in your favor will be extended.
Will be or can be? Where is the policy?
Sir, if you also look at annexure, no, I've got copy. Clause 11 of that policy, 2000 last policy. I have filed it.
Annexure, annexure.
I'm giving it. It is there in the.
Yes, which annexure?
Achha. Page 79.
Page 79.
No, I'm sorry. I'm giving it. So page 68. I'm sorry. Page 68.
68 of what?
Of the writ appeal ballot.
It appeal.
Writ appeal.
You're not annexed it in your writ.
Yes, yes, I have filed it.
You're not annexed it in your writ petition
The writ petition,
because it is not there.
I don't think.
Writ appeal is 1127.
Yes, yes, it annexure 1, page 26 in the writ.
Annexure 1. Okay.
Annexure 1.
One seven, 2013.
No, the writ
To
petition.
the Government of Orissa Health and Family Welfare Department.
Annexure 1. Annexure 1. The Annexure 1 is dated 1/7/2013.
13.
But Annexure 5 is there. That is the agreement.
Yes. The agreement has been executed subsequently. But this they are saying is the guidelines.
No, no question of guideline. They are bound by the agreement.
In that Government Resolution 17/2013, Clause 11, Lakshmi kindly see.
Mr. Mishra, again, we are repeating the same thing that your
Lease may
right
be.
will
Lease may be extended. That is the thing.
your right will depend on, see, this is the decision of 1/7/2013, this resolution.
Right.
Thereafter, the agreement was executed by you, which is of 22/1/2016.
16.
And in that, in clause 11, it is specifically mentioned that medicine not exceeding 5 years. It says not exceeding 5 years.
Not exceeding 5 years.
Yes.
Because the agreement is for 5 years, not for more than 5 years. The agreement is for 5 years, madam.
Yes. So
But
it
there is
was
a
never
clause
extended.
in the government policy. There is a clause. If I read it, if you also permit me, it says on successful completion of the lease period, that is 5 years. Keeping in view of the public need and performance of the lessee during the preceding 5 years, the lease may be extended for a further period of 5 years with 30% increase over and above the license fee and the immediate previous year with approval of competent authority as prescribed in para 2.
But they decided not to extend. That has not been extended.
No, it is there in the policy
It is-
itself.
See, that the guideline permits them. It enables them. It enables the government or it enables the government functionaries to extend.
To extend.
It does not cast any obligation on them to extend.
But I don't say with due respect or obligation. What I say, their own policy says that the lease period 5 years that is given, it doesn't cease as such, and it can be extended if the government's obligation is there to extend it in public interest and the persons concerned. Here, nothing has been shown that public interest will be affected as such if extension will be granted. Rather, it ameliorates and gives benefit to the public. Reason being, if you kindly visualize, we don't object to the free supply of medicine. Let the free medicine.
See, Mr. Mishra, you cannot decide what is best in the public interest for the reason that you are an individual.
Correct.
And you have come here in your own interest.
Correct.
And the public interest is being looked after by the public representatives.
Right.
All right. So it is not that you will decide what is in public interest.
So I am not
and what is
deciding.
Not in public
But,
interest.
let me clarify. I am not saying that. What I say, I just want to submit for lordship the circumstances which requires public interest for opening of a 24-hour day and night. Because they themselves created this policy that 24-hour day and night shops should be there in the in-campus. They themselves decided it is required for public need.
They themselves decided. And you also decided, you also agreed to that you will enter into agreement for 5 years.
Yes.
Now for 5 years, after 5 years, they could have come out with something else. Some other person could have been allotted the same shop for further period of
They can do it. They can do it.
They can. They cannot. They may not.
They
That
may
is the
not.
reason.
They may not.
Yes.
So therefore, the question here is, but this matter was taken up for consideration, as your lordship rightly indicated. This matter was considered by another single judge matter. The honorable single judge decided the matter and looking into all those things and decided no, the license has to be extended. in view of this extension provision contained in 2013. And that was challenged before a division bench. Division was confirmed. That matter was carried to the Supreme Court. That was pending for the Supreme Court. Another judgment was also decided by the Honorable Single Judge, which is now pending in writ appeal before your Lordship. Same point. But that was also brought to the notice of the Honorable Single Judge at the time when the hearing was taken place, that two judgments have come up on the same subject matter. So your Lordship actually judicially propriety requires that once as Honorable Single Judge has decided matters, therefore this either it has to be referred to a larger bench or can wait till the matter is adjudicated for the Supreme Court. But it has been decided one way or other. Therefore, there are two conflicting judgments to Honorable Single Judges, Madam, which is now before your Lordship, Madam. For my respectful submission is that in one of the judgment, the government took a stand, it is in public interest. I am not saying, sir, government took a stand before the Supreme Court that is request in public interest a 24-hour day-and-night stop. If your Lordship kindly look at, with due respect, the compilation given by my friend,
110.
that judgment is there on the last page. I just got a copy, he gave me.
110.
At page 110, the compilation. Kindly have a look at that decision.
Again, Mr. Mishra, we are saying that the existence of 24/7 hours stop
yes,
in a hospital may be in public interest, but your right to continue as
my right is in your Lordship's hand.
No, your right is not in your Lordship's hand. Your right is to be adjudicated in accordance with law. So law will determine your right. Lordship will just.
If your Lordship thinks law will come to my rescue, law will come to my rescue, my Lord. If your Lordship thinks that
Your
yes,
Lordship can tilt, your Lordship can interpret if the Lordship want, and
it can be flexed, my Lord.
Oh,
But if your Lordship kindly turn to page 110, my Lord.
page 110 of what?
In the compilation, my Lord. In the compilation given by today, my Lord. Page 110.
Yes.
If your Lordship looks at paragraph 2, it's the short question that arises for our consideration is that this appeal is whether impugned order of the High Court passed in OJC so-and-so directing the appellant not to take any decision on the advertisement issued 27/7/93 issued by the Superintendent CDM of Balangir to settle the shop room with anyone to hold a medical store inside the hospital premises, Patnagarh, could be sustained in the absence of material to show that said decision of the government is arbitrary and opposed to any rule or regulation that we have. If your Lordship kindly turn to paragraph 4, page 111. But respondent 1 to 7 were opposing actually that. It appears that during the course of argument in the petition in the before the High Court, the Superintendent CDO Balangir was personally present in the court, who in response to the certain questions put by the learned judge states the whole purpose of the advertisement is to make available medicines to the patients day and night. However, the High Court allowed the petition of the respondents, directed no decision shall be taken on the advertisement to settle the shop with anyone to hold a medicine shop inside the premises of the sub-regional hospital Patnagarh.
This decision
If the
is
petitioners,
This is against you,
This is
Mr.
against
Mishra.
you. You're reading the wrong judgment. This decision is against you.
it's not against me, my lord.
It upholds the decision of the government to open a day and night shop inside the
No, it
hospital.
is in favor of that. Government decided to have it.
Yes,
Opposite parties opposed.
yes, they were outside. They said we have a shop.
High Court said,
yes.
don't do it. Supreme Court said, no, do it. If you look at the last portion,
Yes, so the
paragraph 6,
policy of the government to provide
day and night
medicine-
stop inside the campus.
yes, the object is to provide medicines throughout the day and night.
Inside the
Yes,
campus.
yes.
So that is my favor, my lord.
So how is it your favor?
That's what it. That's what we do.
So we actually want that.
No, no, you want that, but whom the government will give, that is the problem.
Here, what I wanted to say
It is not in dispute that the shop will be there. The problem is who will get the shop, right?
Hey, Lakships, may I just?
Yes, of course.
May I just go? Should I speak?
Yes, please.
In fact, my submission would have been actually this, that we need to see it in the correct perspective. These policies have been existing since 1980s and continuing from time to time. And they have been, time to time, there's been upgradation. First, it started with big medical colleges, then it went to the smaller medical colleges. And that's how we landed up here today. In these policies actually control how the government is to deal with these shops. And your lordship probably
Let him
assuming.
complete. Let him complete.
One thing, we are assuming that there is a decision not to continue. That is not there. If your lordship will look at the original impugned order in the
Madam, again, we are coming back to the same question. Your right to continue, that's all.
Yes, your lordship.
If you have a right to continue, you will continue. If you don't have, you will not.
See, if the policy and the agreements are seen together, that's why, your lordship, one of the arguments was on legitimate expectation, which has been incorrectly decided by the single bench.
We will see.
Yes, sir.
See, let him.
I can't put my right also in this.
Please, when did you join? When did you join? No, when did you join?
I won't intervene.
No, please.
Lordship, I won't intervene.
Please, we want to know.
Your lordship,
When did you join, madam? Why don't you answer?
3 years.
When was he designated senior advocate?
Your lordship, that's what I'm saying.
When was he designated? When were you designated senior?
I know where your lordships are taking.
Sir,
But
when were you designated senior advocate?
2005.
2000. Oh.
Lordships.
Please, let him come.
Actually, I became a senior advocate on the day along with her father.
All right.
Same notification. Unfortunately, out of 7, 5 are dead.
Yes.
Sir, here, if your lordship, what I wanted to show that why that judgment was shown to clarify the position, Maran. But there, government took a stand. 24-hour day and night is required for public interest. Just I wanted to bring your lordship. Before the Supreme Court, they filed affidavit. CDMO appeared and said, we badly require it because life-saving drugs and all those drugs which are not available elsewhere.
Absolutely, we agree.
So they use.
It is still their policy. It is only the thing that who will run that shop.
The shop is to run by a person who has been granted the license. But license has been granted to 5 years with the term to extend it. But if I invest money, let's say kindly see, I procure drugs, I keep it in there, stored, freeze is there, everything is there, all life-saving drugs are there. I maintain it by spending huge amount of money from years together, and that is being renewed from time to time. I apply before them, as the provision is there, within 6 months or 3 months before, I have to make an application, and they see that my conduct is good, my performance is good, I will serve the people, and they extend it from time to time. But as my friend has said, when the extension is granted from time to time and the policy is still in existence, the legitimate expectation comes into play. I also has got a legitimate expectation this will be extended again. Now my license is till 2021. When I made an application, they said, no, we have stopped it extension. You can't extend it because of 2015 rule notification. But 2015 doesn't say so. 2015 is a letter itself. It doesn't emanate from the policy decision of the government. Yes. There is no policy, I am saying let the government produce it, no policy of the government to stop this 24-hour day and shops. Once they extend from time to time, and I usually get it extended. They can have 2, they can have 3 if they so like, if they want to give somebody else. But the question is, if I am continuing and my conduct is good, my performance is good, and I serve the people, but they cannot just throw me out saying, though I have invested money now, from within 7 days, you stop it. And interestingly,
therefore, Mr. Mishra, there is specific
mentioning in the agreement that you will not create any permanent structure, one, and two, you will remove the temporary structure as and when required.
Yes.
by
But
the
I
minister on 1
concede
month's
to all the
notice.
terms and conditions. I have never violated anything.
There is
Now
no
what I
question
say,
of violation. The question that you are saying that you invested so much, you did this, you got a refrigerator or whatever. Right. So that cannot be ground.
but the reason, my lord, kindly see, I have a look at, my lord. The
Yes.
reason for which they say will not extend. The reason being Niramaya scheme.
No.
The reason being they have given a reason, but not that without any reason. So the reason is not sustainable, my lord. With judicial inquiries, if your lordship kindly look at judicial propriety demands that they should not say this is the reason on the basis of which is when the policy doesn't say so. Policy doesn't say you stop it. If you look at Annexure 4, my lords, kindly have a look at Annexure 4. The compilation. In the writ appeal, I have given it.
Annexure 4 of?
Well,
Annexure 4 of what?
One second, my lord. Sorry, Annexure 5, page 74. 27/2/2015.
Of what? Of what?
Of the writ appeal.
Annexure 4.
5, my lord. Annexure 4, page 74. It's a later date 27/2/2015.
Annexure 5.
Yes, my lord. I am directed to say that the state government is committed to provide free medicines to patients as public health facility with setting up 24/4 drug distribution counters through Odisha State Medical Corporation at Government Medical College and Hospital, so and so. Funds have been provided in the state budget for that purpose. It is therefore been decided that no extension of lease on campus medicine stores be done till further orders.
Yes.
No new opening campus medical stores be allowed. The drug control Orissa is instructed to be on alert while renewing the license on these drug stores. And this is until further orders, it's not the final order. They have to take a final call on this. If your lordship turns to
Yes.
agreement that was executed in my favor in 2016. I've got it at page 85.
That we have seen.
Page 85.
85. That we have seen.
Page 15 says that in case of breach of any of the terms and conditions of this agreement, or in case of negligence or failure at the time during tenure of this lease by lessee, it shall be sufficient ground on the part of the lessee either to retain this agreement after curtailing any of the rights and privileges thereby granted to the lessee, or to disallow the said lease to carry on business as any more in the hospital campus. There is no allegation of breach, my lord. And an undertaking has been taken also at page 91, if your lordship looks at it. where a deposit of 1 lakh has been taken.
So you are seeking a direction from the High Court to extend your
Yes.
period of lease.
Right.
This is the direction you were seeking before the learned single judge.
No, sir. I'm seeking direction. They should not. The government should not take a decision to not to extend on the ground.
See, how can you put that in this way?
Well,
Your
yeah.
lease expired. We don't know what was your release sought before the learned single judge. But what you actually wanted was extension of the term of your lease.
Right.
So indirectly, you are seeking a direction, or you were seeking a direction from this court to extend the lease period in view of the guideline. Or you might have argued that it was obligatory on the state government in view of the guidelines to extend the lease period.
Yes, in view of the guideline of 2013, the last of such guideline, where there is a specific clause that government is to extend after completion of 5 years
Is to
on
extend,
increase.
may extend. Is to extend is not there, may extend.
2013.
That guideline.
Yes. 2013 guideline. If you're
Yes.
May. Sir, may is there. Sometimes the may has to be read as shall also. But what I beg to submit before Lordship, if they say that at an enhanced rate, what does it mean, Malad? They want money actually, increased price. So if I'm ready to give it, Malad.
Yes.
Yes. 2012.
And interestingly, my friend is correct. Page 65, let me kindly see. That 2012 modification made to the guideline. 13 is the last.
Page 65.
Page 65, clause 4, Malad.
What for?
Eligibility criteria for opening medical shop will be as hereunder. The allottee should be an unemployed registered pharmacist under the Odisha Pharmacy Council and a permanent resident of the district which the shop is to be opened. He must be unemployed and a registered pharmacist. For all these conditions, but other conditions regarding submission of certificate and everything there. But then I have to be unemployed. I should be a registered pharmacist. But because they just want an unemployed persons can be deployed and to open a shop for his livelihood.
So they may be again wanting some unemployed persons to be given this opportunity.
But they actually select out of many. But it's not that I was the only person. Out of many, actually they select me to be the suitable.
For 5 years.
5 years. 5 years. With a clause of extension, if I read it again for a fellowship, on successful completion, that 5 years with 30% increase the material merit. But if there was no clause for extension, if they were decided, this 30% increase wouldn't have been there. Obviously, with their choice, I cannot say that they should not have the option. But the option has to be exercised in a reasonable way.
Yes.
But if a person is continuing as such,
yes,
it cannot be curtailed. But some of the persons who are still, the license is there, now they have been asked to vacate also.
Yes.
Some of the person whose license is still valid, they are also asked not to continue. Within 7 days, you vacate. For their own terms and conditions, 30 days notice to be given. That has not been complied with. And the Honorable Single Judge has dealt with the matter. The other judgment matter, Justice Sinha's judgment matter. If you I have annexed that matter. Kindly have a look at the judgment.
So whether that has been challenged?
Read appeal is challenging read appeal. List
No.
No, that has not come before Lordship, I think.
It is there at page 144.
Page 148, if your lordship looks at. Yes, fact show the prisoner seeking to continue to occupy under license and operate medicine shop inside the hospital premises. Prisoner effort to have license renewed have been registered on the basis of impugned circular. Impugned circular has not been given effect to by the state. On this fact, question for consideration is only whether relief sought for the petitioner to continue under license is to be granted. It appears from clause 16 of the license that there can be termination if it felt that lesser that license cannot be allowed to carry business in public interest. Of course, but that your lordship asked
No,
the
but
question.
whether in this decision, the agreement has been read. The terms of agreement have been taken into account.
Yes.
In the order passed by the learned single judge on 8/9/2022. The agreement has been taken into account or not? Because that is the foundation.
2022.
Yes.
Issue judgment. Judgment. No, he has not
Whether
dealt
the
with that.
terms of the agreement for granting the relief have been taken into account or not?
No, I don't think so, Bharat. If you also kindly see that judgment.
Yes, we have seen.
Last.
Para 17, they have framed the legal question.
If you lordship kindly turn to page 131. Or 130.
Yes.
That's the operative portion, in fact. For free medicine distribution scheme, the heading is D, whether action of the state government by impugned order is capricious, unreasonable, or arbitrary. Free medicine distribution scheme, that is
You are reading 131.
130, 130.
130. Yes.
Free medicine distribution scheme, that is Niramaya scheme of the state government, as discussed above, aims at distributing free medicines and consumables to all patients who visited government health institutions. It is a scheme that is founded on social welfare consideration and aims at making healthcare affordable for common man. The scheme by itself is necessary for a government undertaking to make medicine free to all its citizens laudable. It is an unavoidable truth that confidence in the healthcare system is often lowering among the people in rural area. Those belonging to modern marginalized class and tribal groups, these were insured cover, and among households with low income and educational attainment, which has consistently raised concern about the equity in the healthcare system for varying popular groups. The state of Orissa, with its divergent population, is no stronger of this concern. In view of the same, from common man's perspective, an affordable healthcare system will naturally make for an accessible healthcare system. When a man no longer bears the agonizing burden of wondering how he will afford his wife's life-saving medicine for low blood pressure during pregnancy, his heart liberated to solely focus on rushing her to the nearest healthcare institution, ensuring she receives the urgent care she desperately needs and deserves. The scope of judicial review when examining a policy of the government is to examine as to whether it violates fundamental right of the citizen or is opposed to the provisions of the Constitution or opposed to any statutory provision or is manifestly arbitrary. Courts cannot interfere with policy either on the ground that it is erroneous or on the ground that a better or fairer or wiser alternative is available. Even otherwise, the fundamental freedom available under the Constitution have always been subject to a reasonable restriction. The state government's policy decision in the present matter by the impugned order do not to renew, but it's not the policy decision, not to renew the license or granted fresh license to the private on-campus medicine store is decision found on sound public interest. as submitted by the opposite party state, the petitioner are not barred from operating medicine stores elsewhere.
Yes, we come to page 120, where the agreement has been dealt with. And we'll learn single judge in paragraph 7, subpara 17 at 121.
120 minutes.
121, page 121, Roman 17.
Roman 16 minutes.
17.
17.
121, Roman 17.
171. Considering the aforesaid procedure, guidelines and clause of the agreement between campus medicine shop proprietors, hospital, it is evident that these shops and proprietors held only license, signifying permission possession of space upon government expiration, they lack the right to request for extension. As the agreement functions as license, there is no transfer of property interest to the licensee, hence no irrevocable right to license. There, with due respect, my lord, here the court has committed a not taken note of that the policy says renewable part.
No, right. He says right. Oh, that is enabling clause.
So the enabling has not been taken note here.
All right.
The enabling part of the policy, clause 11, has not been taken, and the Honorable Court thinks upon agreement expiry, they lack the right to request for extension. So the clause says you have the right to seek for extension.
Maybe the expression like right to request may be right to extension.
Right to extension.
Instead of right to request. And then
no, I don't have a right for extension, but I have a right to seek for extension.
Yes.
So that has not been taken.
All right. And then as the agreement functions as a license, there is no transfer of property interest in the licensee, and hence no irrevocable right to license renewal.
So that is correct. But we don't dispute so far as the legal proposition is concerned, my lord.
Yes.
For the present circumstances, if your lordship sees, one policy is in existence.
Yes.
Another policy comes into play. They do not conflict with each other. They never overlap.
Yes.
They never encroach upon the other. Each one is independent and both can coexist. My respective submission is that 24-hour dwelling shop not encroaching.
Mr. Mishra, if you invoke writ jurisdiction, you have to establish your right. And unless your right is shown to have been infringed, the court would not interfere. So that is your basic requirement to establish.
So that is the legitimate expectation. There is one of the function is there is one of the wing of the interference with the Honorable High Court where the legitimate expectation is there, which emanates from the agreements.
Will examine.
And the policy decision, my lord.
Legitimate expectation arising out of the policy decision.
Right. Arising out of the policy decision.
Yes.
And policy decision still subsists. It has not been wiped away.
Yes.
It has not been repealed or withdrawn.
Yes.
When that exists,
yes,
I have a right to apply up to the state to take a decision, my lord.
Yes.
But state cannot take an unreasonable decision. The decision has to be reasonable, keeping in nexus for the purpose it was established first. Since 83, it was required. Now they have not said it is not required. Nowhere they have said 24 day and night service is not required.
That is in a letter. Resolution in the acting is the resolution. Scrapping in the letter.
This amounts to indiscipline.
Right.
All right. If you have to say something, yes. If you have to say something, you please tell him.
Oh, I have said him.
All right. Well, you are saying him looking at us.
I said him that
All right.
He just wanted to assist me, in fact. But here, if you also kind of see, I have got a right for a fair judgment by the state or the authorities to consider it. But the policy exists, no conflict of interest. I am not going to encroach, and there is no impediment to extend it. I can understand that there is impediment to extend. Government says no, we have a policy decision not to extend, but no policy decision is there not to extend.
Yes.
That is all actually the entire sum and substance.
No, 80%.
I have a small date chart. I think that will be, if your lordship will take up WA 963 of 2020.
WA 9?
963 of 2020. Lordships, may I just take your lordship?
One of the top cases.
Yes.
Topmost cases.
May I take your lordships to
Yes.
page 68? Barry. This is, your lordships, the first time when the state comes up with a policy. In fact, your lordships, each policy I have described the relevant portions in my reading itself, just so that we call out only what
It is in the writ appeal.
just to call out, and it is easier. So in fact, if your lordships will look at page 4 also of my writ appeal, instead of, we can just highlight it, page 4 also of my writ appeal. So the policy dated 10/6/1983. In fact, those date charts have referenced both of the paragraphs also, and as well as
Good.
and as well as the relevant page in the of the document also. If you'll actually look at those pages.
Yes.
So if you'll actually look at the policy dated 10/6/1983, it clearly states that the state wanted to open 24 hours basis inside DHH and MCH, that is main medical campuses, after inviting applications. So it was not that somebody was arbitrarily just picked up. And the person selected would be given a license for 3 years, extendable also with 1 year. So they had an extendable clause then also. Such extension was good if sufficient reasons. Now your lordships will look at the relevant portions also.
Page
68. All that I've written is called there, your lordships. Second point is there. The hospital advisory, the persons who select shall be given a license for a period not exceeding 3 years, established a drugstore for sufficient reasons of license may be extended for a further period of not exceeding 1 year. And then they had a deposit also. And the terms of the license will be finalized shortly. My reason of showing all this is how the state has behaved time to time. If it's not seen in the whole historical perspective, maybe I'm not able to make my point. Then comes your lordships, page 74. Whose summary your lordships will in fact find at page 5 of the writ appeal. There was two more policy decisions in between, your lordships, but they're only changing the agreement formats. I'm not going into it. The ones which will probably be required here. So your lordships, according to that policy, there was a reassessment done that whether these 24-hour medical shops are to be open, and then it has to be open after open advertisement. That probably was my ladyship's doubt also, that are you just giving it to selected people? That policy also says that the revised guidelines specifically required execution of right of 3 years and having a renewal clause. And it also provided very strangely provided, as you keep increasing the time period, you'll just pay some enhanced. So this was the continuous dealing between the state and how it expected us to behave. So it's continuously state has been sending this, that please kindly come, please kindly invest. And yes, you would be time to time assuring us some kind of extension through their policy decisions. So the backbone of all these contractual agreement between parties have been these policy decisions. That would be my submission. And these policy decisions have really not been taken in the taken note of by the single judge. Then, Your Lordships, I think the relevant portion would be the policy decision of 2004. That would be at page 79. Relevant portion, Your Lordships, I have described it at page 7.
Policy decision, according to you,
Lordships,
was to have 24.7 and to have the provision for extension.
Extension and also
With enhancement.
Yes, and also through an open advertisement. Not that anybody arbitrarily is being picked
No,
up.
first thing was open advertisement, and thereafter you would continue for
Yes.
eternity.
No, Your Lordship, here I would also say that initially, as I was saying that, initially, in fact, I think as probably was this case in every state. That time you used to have only big campuses somewhere in the big hospitals. So with the development of infrastructures also, even the smaller CHCs and the periphery hospitals became better. And there also that let us have these kind of shops for the public, because Your Lordships at that time investing in medicines did require a private enterprise. Government was not in the able to really provide that. And Your Lordships,
So this situation changed later.
Your Lordships, I would say it hasn't changed. With that also we will point out.
Okay.
Just a matter of buying two medicines from two different shops will show us the situation hasn't changed. I mean, just a personal experience. I happen to be in the SCB Medical College. It's a medicine which requires 5,000 rupees, and you will not find it in this shop. You will have to find it into the 24/7. They can afford, these people cannot afford.
Yes. Then?
Your Lordship, the 2004 policy which comes, which not only is now extending this to the normal allopathic hospitals, but even to Ayurvedic and homeopathic hospitals. The same policy decision, 24/7, after reassessment. And here again, Your Lordships, there is an enhancement of license fees, and as enhanced to 75,000. So there is a continuous policy decisions inviting us. And the term is for 5 years, extendable by 5 years. When this is there, again 2012 policy comes. With again term of 5 years, extendable for 5 years, enhancing the licensing fees.
So you were beneficiary of which scheme? First scheme or the last?
No, we have been there. We've been there from 82.
80.
At least my client has been a full-timer. So.
Unlike Mr. Mishra's.
No, I think Balesa comes up very recently.
Right. Yes.
And Your Lordships, here the enhancement is to 1 lakh. With same hike, and also for each year 30% hike. Then Your Lordships, the 2013 policy, which Mr. Mishra my senior just read it. Now in this background, we have been continuing. What happens is, Your Lordships, that policy which today actually the single bench discussed, saying, and there was a lot of laudable reasons written that, medicines should be provided. That policy has actually not seen the, the light of the day when the letter dated that 27/5, yes, 2015 letter comes,
Annexure 4,
which is Annexure 4 in my writ appeal. 101. Now, Your Lordships, my preliminary submission, this is not a policy decision. This was only an administrative instruction or an arrangement. And may I, even though Mr. Mishra read it, I just want to reread it. Annexure 4, 101. I am directed to say that the state government is committed to provide free medicines to patients at public health facilities, setting up 24/7 drug distribution counters through Odisha State Medical Corporation. There is a medical corporation here. At Odisha, medical college hospitals, DHS, HS, and SDHS and CHS funds have been provided with the state budget for the purpose. So but the policy which actually implemented this first paragraph, that hadn't come. They only stated It is therefore decided no extension of lease on the campus stores to be done until further order. So this is very evident. This clearly shows they were also not sure how the picture would look like if we only rely upon our own resources. Because your lordship, they are all generic medicines. Some of the high costly ended medicines are not provided by these stores.
How do you say that?
Your lordships, in fact,
You cannot.
your lordships, they actually are not. In fact, that's one of our pleading which we have taken
It
before.
is very
the
difficult
system.
for you to, yes.
No, we have taken that here, there, and here also. Probably the data is called for from the state government, that will also clarify it. Your lordships, my entire
Is
reason of
is your turnover more than Odisha State Medical Corporation?
no, your lordships. But the problem is, even my individual turnover, I can get that cancer medicine which they will not provide free here.
Don't know.
Lordships.
All right.
That's actually
All
one
right.
point of contention. My
Yes.
reason of placing this here is, it wasn't a blanket order not to extend. It was only a halting order where government is also keeping its options open, and this is the order which was under challenge. What the single bench thought, that the subsequent policy which has come to implement that fee distribution is under challenge. Now that's the first mistake of fact before the single bench. That's what I wanted to point out.
Yes.
Then, your lordships, I would like to just show the policy which comes thereafter. No, your lordship, that policy I haven't given. No, actually, page 92.
Is the next year?
3. It adheres, no? Now, you'll also see the first order which I just showed was the impugn order was 27/2/2015. The final order is the order which is implementing that free distribution comes on 25/4/2015. Annexure 3, page 92.
No, the annexure 5
4
is dated.
4. You also my
No, annexure 5 is dated.
25/4/2000.
Annexure
Annexure 5 you are referring to just now.
Annexure 5 in his brief, it is annexure 4 in my brief.
27/2/2015.
In your brief, it is annexure
4. 101.
101. All right.
Thereafter comes the policy of the government, which is 25/4/2015 at annexure 3, page 92.
Yes.
This is simply, it says, the Odisha State Medical Corporation has constituted the resolution dated so and so for implementation of free medicine distribution scheme in all government health institutions. For successful operation of scheme, the procedure as specified and annexed to this order is hereby approved for guidance of all concerns. Now, this is what was put for guidance. Now, all that this policy says is, your lordship, that there will be free distribution. It says drug distribution centers, DDCs, will be set up in every medical facility. It means big medical colleges and hospitals, the district medical hospitals, everywhere. Drug distribution center. And what will happen? Prescription-based medicines would be provided there, free of cost. It doesn't touch the aspect of what happens to the existing 24/7 hospital. It does not say anything, does not touch anything. And that's precisely what the single bench should have seen. Because the single bench's whole decision is that, why should I disturb this policy decision?
Yes.
When there was nothing told about our continuation. That is why Justice Sinha's judgment said that this policy is not talking about you being thrown out. And I don't find anything emanating from the counter or from the impugned decision, which is also the impugned order there, which says your continuation.
No, but the main problem with that judgment is that your right flows from the agreement, and that agreement has not been taken into account.
Lordship, that's the reason why I specifically placed the impugned order. In impugned order and policy taken together, the state government is still had kept us in flux. But we are not saying you will go away. We're just temporarily holding it. We're just seeing what is going to happen.
Yes.
Now, that being the situation here, Lordships, we write that, our term is coming to an end. Please kindly extend it. Because the policy also allowed us to make such a request. Then they say, we cannot accept your request for the time being because such an executive instruction, which is that annexure 4. That's all they say. May I just show that order? Page 103.
Yes.
I'll just read the second paragraph. Further, I am to inform you that as per the letter dated...
No, which page?
Annexure 6, page 103.
Yes. Yes.
Further, I am to inform you that as per the letter dated so and so, it is strictly instructed no extension of lease on the campus shall be done until further orders. That's the reason they cite. They do not say that you do not have a renewal right. They do not say that, your existence is bad.
Did you pay any amount after expiry of the...
That I would have paid only, I would have offered it only with that.
So you are doing that under the...
No. As we have continued, we have made our payments. As we have continued, we have made our payments. By the order of the court, we have made our payments. Yes. Payment. Enhanced rate.
Enhanced?
Yes, because 30% enhancement is there.
30% enhancement.
So, Your Lordship, here I would also try to bring Mohinder Singh Gill, is that the reason here is not cited that my existence is bad, or that it will not allow the 2015 policy of DDC centers to work. The reason here is that you do not have a right of renewal. The reason is simply this executive order is there to keep everything on hold. And I would...
No application, madam.
Your Lordships, I would bank upon Mohinder Singh Gill to that extent. That they can't improve the reasons through counter affidavit.
They cannot.
Yes, Your Lordship.
The question is that can we decide your case without counter affidavit?
True.
We can decide your case without counter affidavit. Yeah, so we can ignore the whatever has been stated in the counter.
I would come to that.
We will decide your right based on your pleadings.
Your Lordship, very strangely what has happened is in that single bench order, the portion which Your Lordship just asked us to read about the clauses of the contract, the judgment has been referred to actually reject our case. That very judgment says whether it's a licensee, whether it's a lease, the touchstone for the court or the litmus test for the court to see is what's been the behavior of the state. Because discretionary power also, Your Lordship, in 2006 has clearly been laid down. It's an art of discernment, not merely I have a discretion and I just say no. It's an art of discernment whether I should exist there or not.
Yeah.
And in fact, I would say it could not have been this common order. It should have been a subjected order looking at each campus otherwise. The fact that it's a blanket order that all are being halted, maybe in a big campus like SCB, where in fact the entire state depends. Everybody, irrespective, wherever colleges have been there, everybody depends here. There maybe the case is different. Or maybe on a small CHE, the case is different. So it should have been a subjective decision. That I would take it that way. Now, Your Lordships, my first conclusion from showing this policy and two things were this, that the contractual relationship between these parties cannot merely only be seen by what's written in the contract, but also in light of these policies. Because both of us were expected to adhere to these policies and act according to the policies.
Yes.
And your lordships, the nature of these shops were not such that the DDC centers would be disturbed. In fact, I know your lordships will again tell me that Justice Sinha's judgment has not taken care of the clauses of the contract, but Justice Sinha's judgment has stated as something one point ahead is this, that having both the facilities gives a right to the patient to choose. So that's one aspect which is, of course, that judgment still stands in our favor. So I would bring that to my rescue right now. And the state has not won against that. Now, your lordships, may I take your lordships to the judgment itself? Because my first attack to the judgment is this: the court has framed wrong issues itself. Had it framed the right issues, maybe the answers were different. Doesn't matter if it was in my favor or their favor. Now, your lordships, the judgment your lordships will find is at page 25. Starts at page 25 in my brief.
Yes.
Your lordships may just look at the observations in para 9.
Yes.
Para 7, actually, your lordships. May just start from para 7, bothering your lordships. He discusses the Nirmaya scheme, that scheme which the DDC centers, is a flagship program of the government of Odisha designed to facilitate the distribution of the complementary medicines and consumed by the individuals assessing healthcare service at government health centers in order to do so and so. So there's a huge discussion on that scheme, as if we are saying the scheme is not to be implemented. But that's where the single bench goes a little wrong. Then your lordships look at para 9.
No, only because the Nirmaya scheme has been dealt with in the order does not become bad.
Yes, I will show.
Nirmaya scheme has been mentioned because in the order which directed not to extend the until further orders in the background of Nirmaya.
Yes.
Therefore, Nirmaya has been referred.
Absolutely, I have no quarrels with that, your lordships. But ultimately, your lordships will find that the touchstone to decide our rights was not vis-a-vis the impugn order that we had challenged, but that, as if the court assumed, the court went under the assumption that your existence is going to defeat that scheme. And your lordships, why I'm saying this? Because it's a very strange observation in para 9. If the court wrote what it wrote in para 9, the question comes, both have continued for so many years and
Madam, you are arguing an intra-court appeal, one. And two, while deciding this matter, we may, the order may be incorrect.
Yeah,
the reasoning may be incorrect. But we have to decide finally what based on the pleadings in the writ proceeding.
Yeah, that's the reason why I did that fact-finding thing before I come here. I'm absolutely aware of that. But your lordships may just look at para 9, because that's also one of the points there. The scheme was implemented in May 2015 and has continued to be operational since its commencement. If the grievance of the petitioner arises with the Office Order 27/2015 of the Joint Secretary of the Government of Health Secretary Department issued to all concerned office. The direction prohibits extension of lease on campus as the government had decided to furnish free of cost and the patient healthcare through Nirmaya scheme, the execution scheme necessary allocation of certain spaces within the hospital campuses. Now your lordship will see, the court was well aware that from 2015 the scheme was implemented, and that we have operated by virtue of the court order. Now this petition gets decided somewhere in 2024. So for so many years, both have stayed together without the scheme being disturbed at all. Now, I think that's, none of us quarrel on that. That is something the court should have kept in mind, is one of my submissions. Now, your lordships, may I just take your lordships to, and that also, some way, disturbs the observation or the counter and also observation of in that impugn order, in our impugn order, that our existence had no nexus in running with that. Because that's also been one of the foundation, one of the findings of this court. Now you'll also look at para 17.
Page?
I'm just 39.
Page 39.
39 of my brief, Your Lordships. Para 17.
Internal page of the order.
No, Your Lordship. Internal page will be 9. 39 is the brief's page number. Running page number 39.
Oh, internal page of the order, you can say from the bottom.
Page number 9 then.
Page number 9.
9.
Yes.
The court framed, Your Lordships, 4 issues. May I just read it?
Yes.
What is the scope of the court's power under Article 226 of the Constitution to review a policy decision of the government and whether the impugn order deserves to be set aside in exercise of the same? Nobody was asking the courts, there was no prayer to review that policy decision. So this issue itself is wrongly framed. That's my submission.
Accepted.
Left to Your Lordships. But the impugn order itself was not a policy decision, is our next submission. It was merely an administrative instruction. Whether the agreement entered into between the parties was in the nature of lease and license. I would again submit, therefore, this second issue really did not go into what Your Lordships are really looking at. The way Your Lordships are actually looking at the agreement right now is not something they looked at. He just analyzed the court only analyzed the nature of the lease and license and quoted a particular judgment and said you don't have a right. And from that judgment only I will show that the finding is wrong. Third, whether the present petitioner had accrued any right to seek extension of the license to run the campus or medical shops by application or doctrine of legitimate expectation. This also he decided only because there is an existing 2015 policies, not how really the law of legitimate expectation formulates. Fourth, whether the action of the government by impugned order is capricious, unreasonable, arbitrary. Here also the reason was simply given that the 2015 policy provides free medicine. No other reasons. Now, Your Lordships, whether I will have an extension or not, whether I'll have a renewal or not, yes, it is the prerogative of the state. But I do have a right that when I do make a request, you consider it on justifiable reasons. Reject it on justifiable reasons. I do have a right like that. And to that extent, I can maintain a right.
Yes.
So let's just now look at each issues as they have been dealt.
Yes.
Yes. Issue 1 gets decided in same year, so internal page 10.
Yes.
May just leave out Roman 1 and 2. There's a general observations of what judicial review is. Even till 1 IV, Your Lordships. They are only judgments. Now they are only judgments. The conclusion part, Your Lordships will find at page running page 14. 14, internal page 14. Nothing is discussed. Only judgments, Your Lordships. Only bare review. With the position of law reproduced as here and above, this court must now examine the petitioner's contentions in light of the same. The petitioners contend that the policy decision of the state as reflected in the impugned orders demonstrated a capricious, arbitrary, and not informed by reasons also infringes the fundamental right. In this view, we consider it opposite to examine the policy decision of the state vis-a-vis the grievance of the petitioner on the following grounds. So they don't really analyze that there was no prevention. I mean, those factual aspects have not been analyzed. The court straight comes to the nature of the lease, but not from the way Your Lordships are now putting us in. B, whether the agreement entered between the parties was in nature of a license or lease. see whether the parties had any accrued right to seek extension of a license on on-campus stores by the application document legitimate expenditure, whether they actually. So all the rest three are clubbed here. So though it did go into this aspect that whether policy, I mean, all the jurisprudence of policy decision, it had started with only discussing the 2015 policy. But what did the policy say? And what is its implication on ground realities? And whether it really, the action that we were challenging was infringing that policy decision, none of these discussions really happened. So that's why I say that it missed the correct legal issue which it should have addressed.
Yes.
Now, your lordships, so therefore I would say there's no finding really. It's only jumping to other three issues. Now, your lordships will see the second issue.
Yes.
Whether the agreement is in nature of license on lease. After having discussed everything, your lordships, internal page 22.
Yes. Yes.
Now, your lordships, at XIV, it did summarize that there was a time-bound manner, and that there was a renewal and extension clause was not automatic, but subject to certain public needs. It does discuss the existence of the renewal clause. Then your lordships will see it goes to all the judgments, and the finding is page 56. That would be internal page 26.
Yes.
Based on the foregoing inescapable inference, is that the petitioner held only a provisional license for operating the campus medicine shop. License was the license from the drugs controller. Consequently, following expiration of the license, the petitioner lacked any unchallengeable entitlement to request renewal of the respective license. That's all which has been given a finding here. There is no analysis that we had a renewal clause, the policies provided for that, and how the judicial review should look at the matter. It only said so. Now, here, your lordships, may I just point out two case laws, and it will be relevant. One is 2014 2 SEC 657, which that very judgment refers to.
2014.
2 SEC 657. May I just?
It did. Reliance.
May I take your lordships to para 44?
650. Yes.
The earlier paragraph was quoted by the court, but para 44 was missed out. (43) was quoted to deny our case, but 44 was not seen. However, that whole issue that because it's a licensee and you cannot claim para 44. However, that does not mean that a public body like the respondent can arbitrarily decline to renew a license. It is well settled law by the catena of decisions of the court that no public body under our constitutional system is vested with arbitrary powers, as pointed out by the court in Ramanathan Sethi and International Airport Authority. If the board decides not to renew any license, either with respect to a class of licensee or reference to a specific area of land, normally such a decision cannot be said to be either irrational or arbitrary unless there are other compelling reasons to indicate that the decision has no rational purpose to achieve. So therefore, your lordships, we can make out a ground only because on the nature of my agreement, I cannot be shown the gates. That's all the point that I want to make here. That is the conclusion single benches arrived at. Yes, that there was a discussion both on license and lease. And it said that doesn't matter. Writ court doesn't get shut on me only because of the nature of my agreement. That's all the point I want to make here. Now, your lordships, the whole argument again comes back to discretion. That judgment has been heavily relied upon by the single judge.
Yes.
Now, Your Lordship, I want to point out another judgment.
Last line of paragraph 44.
Yes, Your Lordships. If there is no reasonable nexus to achieve, that's what we pointed out. I existed, you also existed, demonstrated factually that both existed like happy human beings.
Unless there are compelling reasons to indicate that the decision has no rational purpose to be achieved.
Exactly. What I mean to say, that's exactly, that means I have a ground to argue before Your Lordships. But what the single judge did, just picked up the nature of my agreement and said that your right is freezed. I am saying my right is not freezed by the nature of my agreement. Only to that purpose I'm saying. 44 does give a light to that. The nature of my agreement does not take away the writ court's jurisdiction to judge how they dealt with my request and whether it was justifiable or not.
Yes.
Now, Your Lordships, next judgment, I'm sure Your Lordships must have seen several times, but still I would
No,
bother
but what
you.
was the background of this case?
Lordships?
Yes,
case that you referred to 2014. What was the background?
It
What
was
background?
Yes, Your Lordships, it was a grant on premises, Your Lordships.
Huh?
And non-renewal, Your Lordships.
Yes. All right. This is the case from Odisha.
A license only gives a right to use the immovable property of the grantor to the grantee. That I think paragraph 43.
No, these observations are all right. We'll see.
Now, Your Lordships, on the whole idea of what a discretionary power is and no jurisprudence on discretionary power,
Yes.
I cite 2006-10 SEC 1. With that mistake has
Yes.
Okay. Now, Your Lordships, may I just point out a little bit? Probably not known to many people. This particular judgment has a corrigendum also, because there was some deletion of paragraphs in the original Supreme Court order. I'll provide them, but there's not much of change. I'll provide them later. However, Your Lordships may just look at 31. 30 and 31. Your Lordship, this is an eye-opener judgment, very beautifully describes what discretion really means. 30, Your Lordship.
Yes.
Discretion, it must be in the page 32 of that judgment.
Yes.
Discretion in general is the discernment of what is right and proper. Not, I have it, so I do it. It donates knowledge and prudence, the discernment which enables a person to judge critically of what is correct and proper, united with caution, nice discernment and judgment directed by circumspection, deliberate judgment, soundness of the judgment, a science of understanding to discern between falsity and truth, right and wrong, between shadow and substance, between equity and colorable glosses and pretensions, but not to do it according to will and private affection of the person. Now, the fact that that particular administrative instruction was only keeping it halt because the state was yet to exercise its discretion subjectively, at least if I don't make out a case blanketly. And Your Lordships, one more paragraph. It in fact happens to be one of my favorite judgments. 35 E, marginal note E.
Yes.
Discretion means when it is said that something is to be done within the discretion authorities, that something is to be done according to rules of reasons and justice and not according to private opinion.
Yes.
According to law and not humor. It is not arbitrary, vague and fanciful, but legal and regular. So you are saying, yes, there is a policy here. You are saying, halt it.
Yes.
So you could not have come upon a blanket order if you actually made a judgment of facts and figures. Because Your Lordships, all the time those policies said...
Yeah, just for the sake of clarification, come to page 34.
Of that judgment?
Of the decision, yes.
Yes, Your Lordship.
Second paragraph.
Judicial review.
Yes. So this matter is manner or matter? Seems there is a typographical.
Yes, maybe that is the reason why that only in these 2 pages that corrigendum was there. I'll provide that corrigendum. In fact, it's not even there in AIR. It's not even there in not even SEC online. It had come with the publication of that book. And some
Which
of my
book? SEC,
the book has that corrigendum. So, Your Lordships, at least I do make out a case that no facts and figures were taken into consideration. The order comes even before the policy, and the fact that 10 years we have lived as happy husband and wife, so should not be a problem to see that, you had to do a little more fact finding instead of blanket orders. In fact, of course, I have a matter of a renewal of a license. At least the court did remand the matter back that your exercise of discretion cannot be arbitrary. Just one line statement with a single order, which takes note of all the. That's only in the insistence of my advocate records.
21.
Yes, but paragraph 21 of the judgment beautifully summarizes everything. And also, I think it takes care of Your Lordship's concerns also. And how renewals have to be dealt. I'll provide one more copy. I'm so sorry, my ladyship.
Sometimes.
Sometimes
he is also ignored.
No. I would never do that.
Did you mark what he said?
I sometimes believe that if you could have a soft copy system, I think they are coming up with Supreme Court there we can exchange even judgments.
Yes.
Now, Your Lordships will see. Now they apply the doctrine of legitimate expectation as 3. See it. At 26.
Judgment.
Now, what this legitimate expectation we based upon was, please look at how the state has operated for so many years. And at least legitimate expectation says, I should have a fair treatment before I'm shown an exit gate. With justifiable causes in light of...
You were outside the gate already. It is only because of the interim orders passed by the court that you have maintained your position.
It was a parking zone.
Out of 147, 87 are surviving because of lordships.
No, I think I was in the parking lot because
the rest of they are not there.
I would say
in the judgment
still in that parking lot because I did make a request, and I do have that my requests are dealt within the meaning of these judgments.
All right.
Now Your Lordship will see the legitimate expectation. The first Roman numbers only deals with the number of campuses. Then it's all the judgments, Your Lordships.
All right, we'll see.
And the finding is at the judgments number page 32.
Yes.
Only after all the judgments. In the aforesaid judicial precedents, this court acknowledged that the paramount public interest motivating the policy change must be duly considered while evaluating the petitioner's claim of legitimate expectation. That is why I say that the court did not look at the impugn order. It only looked at the 2015 order saying that there is going to be new free distribution. Given the agreements in nature of a license renewal with regard to public need, it appears improbable that they could engender a legitimate expectation for the petitioners. But the case law of the legitimate expectation says that at least a few aspects of administrative law that my renewal application to be considered justly is a part of legitimate. At least that much I can expect. Mere anticipation of permission to continue does not suffice unless backed by legal sanction. Consequently, the court finds that the validity of the argument of the petitioner have acquired an indefinite right to sustain solely based on legitimate expectation doctrine. Even if the expectation exists, it can be superseded by public interest. Now, that's the question. That means you're again relying on the 2015 resolution. But 2015 does not ask our discontinuation. Neither any data was produced before the court that there was a conflict, that when one continued, the other deteriorated, or there was any problem. Rather, 10 years have acted in our favor.
Yes.
Now, your lordships will see. May I just show one judgment here? 2012, 11 SEC 1, and the other one will be 2005, 1 SEC 625.
2012.
11 SEC, page 1. Are at a body?
Yes. What is there is there in Moneth?
Lordships. Your lordships will look at page 110 of that judgment.
Is there?
From para 188.1 to 188.5 is what I would like to place. Did your lordships get it?
Yes.
The doctrine of legitimate expectation can be invoked as a substantive and enforceable right. The doctrine of legitimate expectation is founded on the principle of reasonableness and fairness. Blanket order, according to me, was not reasonable. Discretion not backed without any data. The doctrine arises out of the principle of natural justice, and there are parallels between doctrine of legitimate expectation and promissory estoppel, where the decision of the authority is founded in public interest as per executive policy or law. The court would be reluctant to interfere with such decision for invoking doctrine of legitimate expectation. The legitimate expectation doctrine cannot be invoked to fit us the change in administrative policy if it is a public interest to do so. That's why I say you come with the change of policy. We have not challenged that change of policy. We are not, our existence is not affected, their existence not affected. The administrative decision is only temporary in nature. They were yet to take a decision.
See, these observations are in entirely different set of facts.
Absolutely, yes, sir. But I think these do apply to my case because there was a blanket order.
Or there is no blanket order. Please come to the next step.
The next judgment would be 2005 1 SEC 625. I know your lordships may not particularly
page
5 years. Sorry, 625.
You know what?
625. Because this is again a promissory estoppel and a taxation matter. So I'm sure your lordship knows the whole para 8, your lordships.
Yes.
A person may have a legitimate expectation of being treated in a certain way by the administrative authority, even though he has no legal right in private law to receive such treatment. The expectation may arise either from a representation or promise made by the authority, including an implied representation, or from consistent past practice.
Yes.
That's the reason why I was showing the entire policy decisions.
Yes.
The doctrine of legitimate expectation has an important role in developing law of judicial review. It is, however, not necessary to explore the doctrine. In this case, it is enough merely to know the legitimate expectation can provide a sufficient interest to enable one who cannot point out the existence of a substantive right to obtain the leave of the court to apply for judicial review. It is generally agreed that legitimate expectation gives the applicant sufficient locus standi for the judicial review, and the doctrine of legitimate expectation is to be confined mostly to the right of fair hearing before a decision which results in negativity, a promise or withdrawing an undertaking is given. The doctrine does not give a scope of claim straight away from an administrative authority, so on to crystallize right as such is involved. The protection of such legitimate expectation does not require fulfillment of expectations where an overriding public interest requires otherwise. In other words, where a person's legitimate expectation is not fulfilled by taking a particular decision, the decision maker should justify the denial of such expectation by showing some overriding public interest. So that overriding public interest, which they say, which was incorporated in that administrative instruction, wasn't a policy decision really, and it was only deferring the decision, not So therefore, the discretionary has not been exercised really, and it should have been subjective with nothing else. Now, Your Lordships, having said all this, what did the court do? The court, while deciding this point, may look at the page 33 of the judgment.
Yes.
First paragraph. It did not go into that administrative instruction. It said, the free distribution medicine scheme comes with so and so objectives. And then, all those portions which Mr. Mishra laid out.
So, the sum and substance of your submission is that the learned single judge was overwhelmed or got swayed away by the policy of the state government,
which really wasn't under
by
challenge.
deciding your right.
Yes, which really wasn't under challenge. Neither the state government's decision really says that we will absolutely throw you away or based on coming of the DDC. So that's the reason where I say that probably the legal issues, which must be the fault of either party arguing it, because issues have to be provided on both sides. This is my submission, should have been that whether the state can act arbitrarily while denying a renewal or deciding on the renewal. These should have been actually the legal question. And whether the continuation of the medical store really disturbs that 2015 policy, and
So
what really is the nature of that imbue letter.
You mean to say both can coexist?
Yes, that it's also demonstrated the fact that 2015 that policy was implemented. We have continued for 10 years.
Why?
True, but Your Lordships, they could have also bring up data, existence of this interim order, did not allow the DDC to operate, but rather the DDCs have operated. We have also operated. So that's what I mean to say is.
One question which is not there on record.
Lordships.
Whether for registration of patients in the hospitals, any money is charged.
No, it's free. Here everything is free.
So if the government conceptualizes a situation whether there is no transaction within the campus of the hospital for having the services or for having the medicines, the moment you enter into the gate of the hospital, into the campus of the hospital, everything is free. So this is the concept. So like anything, nothing which deals with money, deals with shall be available within the campus. It's an ideal situation that the government can provide.
Lordships, heavenly situation. I don't deny. Unfortunately, they really haven't done that.
They may do. Because of the court's order, they could not do it.
Your Lordship, what I mean to say is, they were not prevented. They were not prevented to relook at their impugn order.
All right, and you now
subjective analysis.
And now you should be fair enough to your friends also. Give them also some space, some points, some reason. For some reason,
must be
justify.
Thing I have covered
to justify the fee which they have.
Thing I have they must having their own points. Everybody must look at the matter in differently. But so busy to go.
Yes, any other submission?
Some other day, already full.
Not other day. If you want to argue,
I'll argue.
I'll
argue. But it is already full. It will inconvenience.
So you will argue at 4:20.
Well, I'll argue. Because another day, let me keep it on the Mr. Unauthorized also. Supplement bench.
All right. I was in fact referring to the repealed IPC.
What?
In that note, all the judgments which I have cited, everything is there in that small note.
Please.
Your Lordship, taking note of
We will take up these matters again on Thursday at 2 p.m. Because Wednesday I am sitting single at 2 p.m. Therefore, on Thursday I'll take up and we shall finish.
Interim order to continue.
Yes, interim order shall continue.
For 84, my lord, for all the 84 only.
Or 84, yes.
The 29
The interim order to continue.
Yes.
Item number 29.
Mr. Gautam Mishra, we may not take up your matter today.
Yes, yes.
We'll take up the matter on Thursday. That prison.
Jail matter.
Prison thing, yes.
Jail,
Can
jail.
it be at 4 p.m.? Can I?
Oh, 4 p.m., yes. 4 p.m.
Grateful.
Personal appearance.
There are two items. The 41.
29, my lord.
Just a minute.
That's
Item
29.
29.
You want a time? My lord. My lord.
Just a minute. Personal appearance.
Item 41. Item number 41. Yes.
Yes, Mr. Samantra, has he done something?
The office of learned JMFC personal handed over. She has also endorsed this apology letter. On 29th, he went to Harmon.
In presence of CGM.
Yes, just dropping the, because of, have you seen this? Not very happily worded, but
Yes.
intention is clear.
Not happily worded.
Yes. Acquaintance becomes acquaintance.
The contemner is personally present. Stop. In the
Scared of
it has been argued by learned AGA on his behalf that in the light of his earlier submission as recorded in this court's order dated 28/2024, he has tendered a written unconditional apology before the concerned court, that is the Court of Judicial Magistrate First Class, Barpali. Stop. A copy of the,
give it to the
whether that is there in the on record or not in the court.
Yes, my lord, she has got a copy of that.
This is his copy.
Yes.
A copy of
The copy form part of the record also.
that
File it with the memo.
I'll file it with the memo.
a copy of the said written unconditional apology has been produced before us, which is taken on record. Full stop. Next, considering the subsequent conduct of the contemner and unqualified apology tendered by him, comma, the present contempt proceeding is dropped. So stop. Next, we record our appreciation for the assistance extended by Mr. Rautral and Senior Counsel as amicus curiae, and Mr. AGA, learned Mr. Samantran and AGA. Yes. You should not repeat that in future, ever. Never with the judiciary. Never do it. Otherwise, you will be in very serious trouble. Like, we don't know what will happen or whether any proceeding has been initiated.
Proceeding is initial proceeding. So,
So just think of a situation if any
Focus has
disciplinary proceeding is
been
initiated.
called for, but no proceeding has been.
You will be losing your job. You may lose your job. Therefore, don't repeat it. Never. Personal stands dispensed with.
Item 29.
My lord, I'm the counsel for the respondent, my lord. I have taken consent from the applicant counsel.
When do you want?
Any day next week, my lord, at 2 p.m., my lord.
All right, next week, huh?
May fix the
As
date,
requested
my lord.
on behalf of the.
Is there any urgency in the matter?
My lord, my lord.
Find it being adjourned from time to time.
10th, my lord.
This matter on 1 week. Next.
Item 48.
Yes, please, Your Lordship. Even when a common law forum, my lords, the smallest of courts, when they pass an order, that is required to be respected by the parties who are before it or bound by it. And here is a case where the Constitutional Court has passed an order. And what does the Supreme Court, my lords, say on that?
No, what
How
is the
it
matter
to be
about?
respected?
What is the matter about?
My lord, this is a case where, my lords, the petitioner had participated in a tender. He has emerged successful as the lowest tenderer. His case was recommended for issuance of work order. The state government, it has been referred to the state government for approval, even though the contract does not provide that such a approval is required as a part of the contract. But that being so, the state government has been deferring it from time to time, seeking clarification as to what has happened to the blacklisting, which the petitioner was subjected to in the past. Now, this fact of the matter is that the blacklisting, there was a blacklisting against the petitioner, which the petitioner had assailed before this honorable court, and this honorable court had quashed the order of blacklisting. Now, despite the quashing of the order of blacklisting, they did not open the portal by which the petitioner participates in tenders. for which again it was pointed out to the court, and it was only in the intervention of the court that the portal was unblocked. Thereafter, he has participated, he has emerged successful. But even though the same has happened in February 2024, they took it up in February 24, again they took it up in March 2024, and they have been deferring it. And since March, nothing has been happening. No work order is being issued. It's awaiting the approval of the state government, even though the contract nowhere provides that the approval of the state government is necessary for issuance of the work order. This is the background of the case, my lords. Now, in the counter affidavit that they have filed, if your lordship takes the counter affidavit which has been filed, in the counter affidavit, the only thing that they say is that we have in page 3 of the counter affidavit, para 7, last few lines. Third line, in fact, of page 3. Till today, no approval has been granted in favor of the petitioner number 1 company, nor any work order has been issued in his favor. Hence, no right is accrued in favor of the petitioner company in absence of the approval by the state government. Thereafter, your lordship sees your lordship takes para 14 at page 6. May I read from the last line of page 6?
There are two aspects.
Yes, my lords.
One, that as they have taken this stand that you don't have any right, even if you are L1.
Okay.
This is one aspect. The other aspect is that they have a duty to decide this way or that way.
Yes, my lord.
Reject. You may have a ground to challenge or take some decision.
Absolutely.
So according to you, they are indecisive.
They have the decision has already been taken in my favor.
No, the decision has been taken in your favor for some reason or the other. The matter is pending with the government.
With the government, which is not necessary as a part of the contract. The DTCN, it does not provide for seeking approval of the state government.
No, we have taken a decision that to wait for some time.
Wait for some time means, do you know what?
Well,
wait for some time means you are compromising with the public interest.
Well,
so what was the work?
Construction of a road.
Construction of a road.
Construction of a road.
Well,
so you are not constructing the road because of this. So if you reject it, if you come out with a fresh tender, is there any stay anywhere?
No, there is no stay.
So you could have done that. You do something, you take a decision, you could have taken a decision. How the work can suffer?
And every tender, my lords, has a validity period. That validity period also expires, my lords, in the process.
Then they'll have to come out with a fresh tender.
They have already cancelled 6 such tenders where I had come out successful because of the alleged blacklisting against me, which I have detailed at page 90 of the brief. Now, this is a question where the state is, I am pitted against the state, which is mighty, my lords. Can they, my lords, frustrate my fundamental rights guaranteed under Article 19 and 21?
You are absolutely right, and you are making a very reasonable submission.
Yes.
But the question is, can we issue a direction?
Yes, my lords. Your lordship can. For that purpose, one judgment I will just refer to. Paragraph 15 of the judgment.
Yes.
May I please, ma'am? The learned ASG contended that the High Court erred in issuing the direction, which is in the nature of a writ of mandamus,
it is his case that the writ of mandamus would lie only when a statute imposes a duty and there is a failure in discharge of duty. We would think that this is not a matter which is res integra. As early as in Comptroller and Auditor General of India, Gyan Prakash versus so and so, a bench of 3 learned judges of this court had this to say. The first contention urged by the learned counsel for the appellant was that the division bench of the High Court could not issue a writ of mandamus to direct a public authority to exercise its discretion in a particular manner. There is a basic fallacy underlying this submission, both with respect to the order of the division bench and the purpose and scope of the writ of mandamus. The High Court had not issued a writ of mandamus. A writ of mandamus was the relief prayed for by the respondent in the writ petition. What the division bench did was to issue directions to the appellant in the exercise of jurisdiction under Article 226 of the Constitution. Under Article 226 of the Constitution, every High Court has a power to issue to any person or authority in appropriate cases any government or throughout the territories in relation to which it exercises jurisdiction, directions, orders, or writs, including writs in the nature of habeas corpus. I will skip over that, come to next para. Thus, there is thus no doubt that the High Court in India exercising the jurisdiction under Article 226 of the power to issue a writ of mandamus or a writ in the nature of mandamus or to pass orders and give necessary direction.
So what can be the nature of the order? Directing the state government to issue work order?
To issue the work order because they themselves admit that I have qualified. Now, I do not face any disqualification. I qualify, I fulfill all the eligibility criteria, and there is no reason why they should withhold work order.
There is reason. There is reason that you were blacklisted.
I was blacklisted. That has been quashed by the Constitutional Court.
Just a minute. There is reason that you were blacklisted. You were blacklisted because, according to the employer, there was something against you. That order has been interfered with by this court up to by the division bench. Now they are not satisfied with that decision because according to them, the blacklisting was valid. Therefore, they have challenged. So if in the meanwhile, if they take a decision to grant you to issue work order, and finally you've decided that the blacklisting was correct. So,
my lords, to that, my lords, what does this apex court say on this?
Had it been a different dispute, the matter would have been different. But here we are dealing with contract.
It's a contract. True, my lords. I'll come to contracts also. But my lords, before that, what is the code? What is the law which has been propounded by the apex court? My lords, the next judgment which I rely upon is this, my lords. Kindly take. Kindly take para 14. Page 14. Para 14, it begins at page 13. Kindly take page 14.
Yes.
That 14 subpara 4. In spite of a petition for special leave to appeal having been filed, the judgment, decree or order against which leave to appeal has been sought for continues to be final, effective and binding as between the parties. Once leave to appeal has been granted, the finality of the judgment, decree or order appealed against is put in jeopardy, though it continues to be binding and effective between the parties, unless it is a nullity or unless the court may pass a specific order staying or suspending the operation or execution of the judgment, decree or order under challenge. My lord, here is the case, my lord, where no leave also has been granted. And my lords, there's another judgment, my lords. Kindly take the last paragraph of the first page. Though such contention is put forth by the respondent, keeping in view the provisions as contained in Order 41, Rule 5 CPC, unless the appeal is listed and there is an interim order, the mere filing of the appeal would not operate as a stay. If that be so, the judgment and decree dated so and so would inure to the benefit of the petitioner as on today, and the rejection of the NOC only on the ground that the appeal has been filed would not be justified. In that view, the High Court was not justified in rejecting the petition. And there is also one more judgment, my lords, which deals in the realm of contract, my lord. This is of course of Tripura High Court, my lord.
That will not apply. Yes.
The Tripura High Court judgment, para 7, my lords. Yeah. Para 7, my lords. The bona fides of the appellant shown to this court as explained by the appellant's counsel is highly regretted and cannot be said to be a bona fide action on their part. Once there was an order of the learned single judge dated 12/4/2000 so and so for passing appropriate orders within 3 months in offering compassionate appointment to the widow, there was no reason for the appellant corporation to sit over the matter and without being any interim order of this court in the writ appeal, taking a suo motu decision not to implement the order cannot be appreciated. We would have initiated suo motu contempt proceedings against the officers of the corporation for non-implementation of the order, but we leave it open. At the same time, we would like to observe that the officers must take appropriate steps in the absence of an interim order being passed in writ appeal. Preferred, they are under obligation to implement in terms of the directions of the learned single judge, subject to the outcome of the pending appeal and mere filing of an appeal, along with an application for stay of the order of the learned single judge, impugned in the writ appeal will not give an exclusive right to the appellants sitting over the matter.
So therefore, they are not deciding.
They are not.
They are not deciding. They are not deciding because the order of blacklisting that cannot be the basis for rejection of your claim.
That
Because
cannot
that has been set aside.
Yes, my lord.
That has been set aside.
Yes, my lord.
So they are not giving that work to anyone, nor giving that work to you, because they are not satisfied with you.
But that is answered. Can that inaction be tolerated by this court?
We tolerate so many things. They'll have to take a decision.
They have to take a decision, my lord.
Take a decision. File your affidavit.
They have filed an affidavit, my lord. So let us
Affidavit they
take a
have
decision and file it, inform your lordships.
Lordship,
Within a
I'm
specified
citing a
time.
judgment, my lord, with regard to locus standi of the petitioner, my lord.
Who is he?
Now, this is not a PIL, my lord. The petitioner has filed this petition with a prayer to issue mandamus and to issue the work order in favor of the as being L1. Lordship, kindly see the paragraph, page 211.
No. Why locus standi you are challenging?
Because even if he is a L1, my lord, he has no locus standi, my lord. Lordship, kindly see the
Standi, how can you say that?
Right, you can say.
Right to my
Locus standi. Locus standi
Right is different.
my lord.
Affected party.
Lordship, kindly see page 211, last para, my lord.
Yes.
From a bare reference to the aforesaid conditions, it is apparent and explicit that even if the public auction had been completed and the respondent was the highest bidder.
So you reject that.
Mail.
Why is the matter pending?
Mail.
Let an additional affidavit be filed on behalf of the opposite parties, stating as to whether any final decision has been taken based on what is that?
The bid identification number. That is at page 27, if your lordship takes, page 27 of the counter affidavit, serial number 7. That is the tender in question. That is part of it. This is where they have last taken it up.
No. What is the description of the tender notice?
That is, there were improvements such as widening and strengthening of Bhavanipatla, Gunpur, Kashipur road from so and so kilometers to
paragraph 4, my lord, page 3 of the writ petition.
Taken for award of work, for issuance of work order in relation to what is the
Work.
in relation to the technical bid for what is the date?
The technical bid also I have qualified, my lord. That is
No,
over.
we are just describing the work.
The work is there, my lord. If your lordship
Page
takes
13.
page 20, page 13 is there. Page 27 is their document, which defines the
13 is also there.
27 of the counter affidavit. 13 is the DTC. Yes, there also it is there.
Invitation for bids, wide bid identification number CEDPI and R-33/2023-24 regarding improvement
Serial number 24.
slash serial number 24
Page 16,
regarding
ma'am.
improvement such as widening and strengthening of Bhavani Patna Gomupur Kasipur Road bracketed SH44
State highway or what?
State highway.
Ma'am.
From 2/500 to 13/095 in the district of Kalahandi. Stop. Does this matter on 3 weeks?
Item 27. Item number 27.
Yeah.
Item 27.
The forest matter, is it there?
Yeah, first matter, my friend is not there, also.
All right, we'll come tomorrow. So we fix it. Yeah.
No, no,
It's
not
not fixed at all. No. Maybe whether this matter is fixed.
No, no. Now he's calling serial.
Yes.
Right, item 30. That matter, that bank matter, they have filed an affidavit, a copy has been served one day before. So I require a counter affidavit to that affidavit. Just to give me some time. Also fix a date, 22nd or 23rd. I can file my affidavit in the meantime.
22nd or 23rd?
Any day.
22nd is Sunday, so.
Sorry, 23rd.
23rd, discuss matter on 23rd to enable and counsel for the petitioner.
Petitioner, no, not up, respondent. Respondent.
Respondent to file reply.
Reply to rejoinder, what is it? Wait appeal?
No, an additional affidavit has been filed during the course of hearing. And he undertook to file an affidavit, he has filed an affidavit.
Additional affidavit filed on behalf of the appellant.
Item 59, just.
Yes.
Last order, in that last order, my lord.
Let's say fixed at 2 o'clock.
2 o'clock.
Item number 59, my lord, that NOC admission matter, my lord, deputy, as per direction, special messenger was sent and they have appeared also. Special messenger was sent and they have appeared, the case was posted today, as item number 59, my lord. My lord may be listed tomorrow in the past, in the admission, press admission or after.
No, after 2 it will be difficult, but it will be listed tomorrow and you just make a mention in the morning.
First,
Mention.
First hour you make a mention.
Item 58.
Just who is for the other side?
Yes, deputy advocate, my lord, friend has appeared.
Please be here in the first half. We'll try to take up at 11 or so.
Item 58, Milords. Item 58 was specially adjourned to today, Milords. So blacklisting matter on the last date, your lordship had asked to serve additional.
Grant some time to file counter affidavit.
Date may be fixed and they may be allowed to, they may be directed to file counter within that period, Milords.
4 weeks.
That item.
Filing counter.
Item
58.
Item 35. That, on my mention, it was listed today. Your lordship, because it can't reach today, so your lordship may fix up a date.
Which one? Which item?
35.
35.
For the respondent.
35. Who is for the respondent?
I am for the respondent here. Actually, matter remanded from the Supreme Court, there is yet another matter. There are certain amendment applications also have been filed by the other side. It can be taken up after a couple of weeks. There is no issue.
Why? Because the matter, is there any observation by the Supreme Court for disposal?
Nothing as such.
No.
No. There was an interim order before this honorable court earlier. And after the matter was disposed of, the matter was dismissed, the interim order automatically vacated. Then matter went to Supreme Court and it again remanded. My submission is that interim order should revive. But that's right. But I have filed a petition that interim order is required now. And there are some amendments and other things that can be
We can
regularized.
take up the matter next Tuesday
Next Tuesday, your lordship meeting.
at next Tuesday, 2 p.m.
No, what I was not submitting, Lord, subject to your lordship's consideration.
We will take up at 2 p.m.
But they have filed a petition for amendment.
Whatever.
Well, if they, you know what I'm saying, if they insist on the amendment, then I have to file my.
In fact, we don't want to apply our mind now. We'll consider everything on Tuesday.
At 2 p.m.
Right, at 2 p.m. Because the matter has been remanded by Supreme Court. We will see.
Yes. No time limit is granted, but still.
And Mr. Mahanti, it is open to you to file an objection. We don't have to grant you
I
permission.
don't want to file an objection for amendment.
Then
I want to file a counter affidavit for the duly
if that is allowed.
All those issues can be
not been allowed.
Exactly.
That's what I'm saying. That's what I'm saying. If it is allowed, then I'll file a counter.
We will see on Tuesday,
That's
2 p.m.
My lord, item 52, your lordship.
Your lordship.
Yes. Yes.
Item 52, today's list, your lordship.
Yes.
This is your nursing college matter. In
You
which,
had mentioned in the morning.
no, my lord. Now the 52 item.
Why did you not mention it now?
All right.
I have mentioned the memo in other cases.
All right.
But yeah.
All right.
today's list.
All right,
50
Mr.
52
Counsel,
your
come
lordship.
tomorrow. Please
52
come.
your lordship has a fix of that matter, some of the batch of matters for 2 p.m. at 2 p.m.
When?
Tomorrow.
Okay, then
This
Tomorrow at
matter,
2 p.m.
is it those are fixed to tomorrow 2 p.m. Mr.
Tomorrow 2 p.m.
Other matters are they fixed tomorrow?
Tomorrow.
Nursing college. This also is nursing. That is what he's saying.
1 p.m. है करें? 2 p.m.
No, because
I will not say. We will take up some nursing matters at 1 p.m. tomorrow.
yes, my lord, this matter may be. This matter may be.
Yes,
Take
I
up.
am.
Item 52.
All right.
Pardon me, Your Lordship. Item 28, Your Lordship. Your Lordship, in the morning, my senior, Mr. Gopal Jain, made an submission, my Lord. My Lord, although it is not connected, but Mr. Jain was beseeched Your Lordship, my Lord, if item number 6 is Your Lordship has fixed after 4 weeks. If this is on the same day, my Lord, he can physically come to assist Your Lordships.
provided counter is
Item number 28.
No,
Yes, my
whether-
Lord, it is ready for pleading.
No, whether both the cases, see, 2 cases can be tagged. The matters are similar, issues are similar, but they cannot be tagged because counsel are same. Counsel is same.
I completely got it, my Lord. I'm sorry, my Lord, if I said, my Lord, it should be tagged. It may not be tagged, my Lord. I'm only saying, my Lord, it can be taken up on the same day.
That
for
will not be
convenience.
proper, Mr.
Item number 53.
My Lord,
Yes.
my Lord, item number 28, my Lord, 4 weeks after. Any date as Your Lordship, my Lord. Any day.
Item number 53 may permitted to withdraw as the matter is infractions.
Thank you.
Lord, item number 50.
53.
You also want to withdraw?
No, my lord, item 50, I want.
50?
50, I want with the matter. Maybe taken of that.
What is this matter?
No, no, that's matter. Your lordship remember that additional security deposit matter, which your lordship has.
Additional?
Security deposit matter. Your lordship have filed and entry granted and the pleadings is completed. But the work could not be executed because of this litigation.
All right.
I have already informed the Railway Council. They say they have no objection. Any day suits to your lordship board at a specific time.
All right, we will see. All the matters will come on next Tuesday.
May just your indulgence ki at 2 p.m. if your lordship would put it on board.
See, tomorrow after 2 p.m. I am taking up arbitration matters. Thursday we are taking up old matters. Friday
Any date that suits your
so
lordship.
therefore
at 2 p.m.
Tuesday
Wednesday, even, any date that, board is.
1 week up. Yes, can we write now?
Public.
Power net.